What's the order for? When? When was the order?
Order dated 29th of January 20.
So what is the order? When did you apply?
I applied 6th February 2020.
Yes.
In this period, I would put
What to show?
I would put some.
What is the urgency, sir?
Participating in the meeting of the managing.
There is no urgency, sir. You obtained the certified copy. How limitation? 6th of February you filed.
29th of January 2020.
Very good. 6th of February you have. Oh, so very good. Where is the delay? You have applied. You have not obtained. Yes. If you don't get by 1 week, comment it. Yes. Next. All these.
Ali, you did not point it out. One expedition has been disposed of by me.
So that is last location manner, you know, please to formulate 4 points. But I have been asked to find a report.
Item number 2.
Release. Ordered impugn has been passed. As the ordered has been passed by one of us. Mr. Prasad, the report which you gave us in that matter, teacher matter, the report in that,
Yes, Chitran.
that has been, original has been signed by the DI.
Yes.
Huh?
One copy is original and another copy
is in demi paper.
No, Malota, that is what Honorable Malota has asked for it formally.
So that
signed by the DI.
yes. Yes.
No, what happened was, then like inspection, asked inspection, asked
When you were appointed, the school was recognized as a fourth class junior high school. Fourth class junior high school. They, which when was it upgraded as fourth class junior high school?
Subsequently, they are fourth class junior high school, they are 1997.
1990?
97.
Can you give us the date of you were appointed 1st January 1982.
Oh, it, up to class 6
Up to class 6.
was respondent number 6 in the petition.
President by law, president, present president.
So you were 1184 was the fourth class. When was it upgraded as 9 and 10?
Two thousand five.
2005. You were appointed.
I have been continuing since 1997. And yet,
Your appointment letter has been found to be manufactured.
this DLIT instruction report by law, which I applied for under the RTI, that has not been submitted. The DLIT instruction which I have annexed to the evidence.
Yeah, Munindra Mohan Sinha is against you, Mr.
DLIT
That
instruction,
organizing teacher has no right now.
DLIT instruction, these are my name, my appointment. That's why the whole problem is there, my lord.
In DLIT, your name was not there. That is what the DI has observed.
My lord, ask my lord, ask every my lord. Thank you, my lord. 2000 my lord, DLIT instruction order, which I have my lord stated in my evidence in detail. Ask DLIT instruction after that, my lord, after commission of school at 4 was realized. That was there in 2000. So the past April 2000. Subsequently, 4th October 2002. Also, my lord, inspection, my lord, my name, that has not been, my lord, placed in the That's why the whole thing is there, my lord. The basis of that will not support that purpose of my lord upgradation of this school. They stated, my lord, no teacher functions. But the DLIT instruction figures my lord, figure my.
Your appointment letter has been told to be a manufactured one. That is what observation of the DI. Where is your appointment letter?
Seventeen. Seven.
That's he has stated that I have been functioning since my lord September, my lord. The evidence in objection.
Who is for this school? Your what he was working?
Yes,
So how did your headmaster say before the DI not working? When did you become the secretary? You are the new secretary. You are appointed when?
They are similarly also.
Where is that? Show us.
Page 20. With the application of position on behalf of respondent number 6.
17th October 2023, madam, which has been right, madam.
Yes. Page 20. Page 20 is affidavit affirmed by Pankaj Kumar Chakraborty, president of the school.
This has been
Affirmed on 17th July 2023. President says that the petitioner joined the school. Appointment letter was issued. 3 days later, petitioner joined the school.
Who was respondent number 8?
Responding number 8 earlier.
Erstwhile secretary.
Secretary. Page 27.
Purpose of upload is that stated by the notice. That's why you
Have you brought Niranjan Sahu?
Page 20.
No, basically. Ask them. There.
Commission Act came into 1997, came into effect. The day Prasad Vich.
Sir, recover 26 December from 1997.
So prior to Commission Act, he was appointed.
Madam, kindly see one line I provided of certain 36. Madam, neither in all the affidavits, madam, which has been placed before your lordship, also before the madam, is what that this is a manufactured because there is no resolution of the managing committee of the school in the resolution. School regarding the appointment letter. But everywhere, but this should be there. But whether the headmaster is saying that that there is this has been issued by practicing fraud. But no copy of the ballot because all these persons who are affirming it are all subsequent persons. So, this resolution was never placed before any of them. That was stated, but neither the school committee before your lordship has raised that with. Whether without resolution, without the, that is a simple under decision of a
Now in the class 10 high school, all the posts are filled up. Vacancy. Vacancy in which post? Vacancy in which post? How can that be?
They are working.
These two are working. You have not yet filled up the post. Why? You have to write to the DI for prior approval.
We proceed. 2% proceeding. Is good.
How? Who gave you the authority?
Another one is also
Uh-huh.
there. Another one is teacher also there. Yeah.
So you have a right to get teachers on that vacant post. You have to approach the commission now. Where is the resolution of the school? In 1997, the appointment letter which was issued. Kindly come to page 17 of the stay application. Secretary says that you have been appointed as assistant teacher in class history in classes 9 and 10 in the expectation of upgradation of the school. Will be considered only. Now, where is the resolution of the managing committee appointing him? 1997 resolution book he could not produce. Place the same before us. 1997 resolution book, managing committee resolution book will be in your custody.
Actually, at the time,
Right. So Nirmal was the secretary, but there was a managing committee. So where is your resolution?
You come to page 27. Which is the epidemic of Nirmal. He then said, during my tenure in 1996, there are 3 Roman 2. Got it? Page 27. During my tenure in 1996, it was resolved that all class 9 and 10 upgraded section organizing teacher would be appointed. Accordingly, upon taking resolution, managing committee decided. So 2 regulation. So was one at least one. After you got it. Who is the secretary and headmaster now in your school?
Secretary and headmaster.
Huh?
Secretary and headmaster.
No.
President.
So this affidavit has been filed, respondent number 6 on behalf of respondent number 6, Pankaj Kumar Chakraborty. Pankaj Kumar Chakraborty is now president. But the school authority before the TI said that appointment letter manufactured, and as a secretary, as a villager of the school of the village, the school is located, he has never seen the petitioner in the school. It is your statement before the DI.
That time, ordinary is. At present, president take that. Secretary and headmaster is the same.
In 2016, this statement was made on behalf of the school authority before DI. That the petitioner appointment letter was manufactured. Petitioner has never, the appellant, never worked in the school.
Till 2028.
On 3rd June 2016, it was your statement.
Till 2028 December 2020.
2023, it was your opinion. 2018, in Montology opinion.
How can we help you? Why you are functioning? Stop functioning. If you are not getting money, stop functioning. I said you have to, you show something. You have not been able, resolution copy, it was now the new, right, school is, you produce the resolution book. Pertaining, ask your secretary that where is this resolution as referred to in his letter of appointment. Page 17. Page 17, the appointment letter was issued as appointed. I have honored direction of the managing committee to inform you that you have been appointed and the approval of your appointment will be considered only when the school gets recognition.
Yes,
I honor the direction of the managing committee. Then where is the resolution of the managing committee? Huh?
yes.
Huh?
I asked the president.
Yes, ask him to produce or to say that there is no such resolution. Your president is now saying, who is the new president, he now says he himself is appointed later. He says that yes, he was appointed 97. On what basis you are saying?
Because my instruction, yes.
That instruction will not help. Regularization has been stopped. It is only if you can establish that your appointment and you have continued in service, then the question comes. Fact-finding authority has found that your appointment letter is a manufactured one. How can we give you relief?
And place of all the documents are printed.
Where is the resolution?
Two, your contrary stand. Your stand, once you stated yes, he worked. Thereafter, before the DI, you stated he did not work. He was not appointed. So since the school authority took contrary stand, burden shifted upon you. You produce your document to show that your appointment letter is backed by a stipulation.
December 1997. Have you checked up? So please check up Mr. Dhol. He's referring to Niranjan Sahu and to that Amrit Lal. Nirmal Charna Das Adhikari. You check up these two judgments. Court said that it is distinguishable. How it is distinguishable? Because the authenticity of the appointment letter was not there. Here the appointment letter itself is doubtful. As such, court distinguished.
That is why, my lord, they are also not the question of resolution. But nobody is going to find that resolution.
To show us that judgment, that resolution.
But resolution they have stated, but page 20, but in the affidavit ballot of the school operation and
Yes.
but page 27.
In before the writ court.
Yes.
Affidavit filed before the writ court.
Yes.
Page 27. Yes.
But paragraph I.
Yes. He was there, but his DLIT name was not.
The ballot has quite their amendment, but the school authority say that by taking the ballot according upon the taking resolution, the managing committee.
Where? Accordingly, upon taking resolution, the managing committee decided to appoint the petition. Very
This is the
Where is the circumscribe? Where is the circumscribe? Hypothetical. Managing committee so far unrecognized section of the school is a private.
এখানে petition দিচ্ছে কাছে দিচ্ছে। দেখতে হবে।
So law has to be given in.
The affidavits exchanged by the parties we kept on record. So what was
Can you see your last one?
you've seen it?
Take instruction
What?
regarding provision, regarding the provisional bills.
Where is the order impute?
Next, just
Take the mic.
next headmaster of the conference. He retired. He retired on 28 February 2017. After handing over all the papers and all these things, accepted by I have been exonerated and now I prayed for no liability certificate so that the cases came in order. During the outcome, after retirement of within 5 months, about 9 months later, school authority issued a certificate. They are missing trouble. Easily, since 2012 onwards, no audit work has been done. Cash book was not mismatched, and there are some. There are communication is there. AI directed to certificate right of that.
Show us that.
I move the certificate. There are so many correspondence. By this way, I have more than 9 years. Now I move the application for issuance of no liability. Now, in the meantime, after more than 5 months, they issue application 156 3 of the order pass. The fire was issued. The matter is pending since 2017. Now I am interested for liability certificate so that my taxation. But in the meantime, the audit work was done. Auditor has not submitted from their own initiative. Second time, auditor submitted report. No notice, nothing of the sort. Now, the learned trial court said that as the second time the audit report has been submitted, there is a mismatch of fund and all these things. So, and that meant that there is no arbitrary action on the part of the student. Pension. Now, with regard to the provisional pension, that was granted, it has been referred to the principal secretary for decision. Against that, I have sought back to this. The last one is provisional pension. I have talked with my since 2017 onwards, No stay will be granted by the school of issuance of the provisional pension. No minor intention, nothing of this. Intent to ailment by the similarly there. There also was whether my client is for survival, at least for the health itself. This is one. But what I have decided, said I have fund of about 5 lakhs. 5 lakhs some. Now, my lord, since 2017 onwards, like about 9 years has passed, I have not paid any further. So considerable amount is paid to me. I subject to your lordship's bank sanction. This is my that let the respondent authority deduct this amount, kept it in their custody. Let the school authority issue the certificates of pension and gratuity and all these things which is pending. It will be the amount which they are claiming that I have defaulted 5 lakhs. 5 lakhs according to the yes, 5,47,993. That is be deducted. That is be careful. What immediately
Then what
everything has been done.
what were you doing then?
Yes, sir.
2017 you retired. You retired April 2017. Yes.
28 February 2017.
Then what did you do? You were also not in time. Your petition was filed March thereafter.
No. There is a petition. There is a petition. There is 2017 order that not to give any pension because of serious irregularity.
In this petition.
No, are you getting no, this is
Where is that order?
page 200. Thereafter, they preferred an appeal. Appeal court directed to keep the provisional bench. They have accepted the order.
Appeal court directed
They modify the order and directed to keep it the provisional bench. They have accepted the provisional bench. They have not challenged our challenge.
Page 200 and
200. They are directed to cooperate with the investigation. Yes, I have cooperated. No, not at all. Why
we
not at all?
will come back to you. Wait.
Why not at all? Well, I am ready to argue this matter. The school authorities should be clear. They should have come with clean.
Mr. Shah, wait.
They want to install it for other reasons. I should not submit it to court. What is their intention? Yes, all right. I want to keep it. Let it be deducted.
That argument we are considering. Wait.
we have kept in mind.
in 2008 on a day.
So if it was the direction of the appeal court, why did the single judge again send it to principal secretary? When this division bench order was shown to the single judge, then how the single judge has sent that decide this point as to whether provisional pension is payable to the principal secretary? That is the order, na? Order said that now I am sending everything to the principal secretary to now.
Decide whether
Then when this appeal order was passed in 2022, Mr. Das, why didn't you comply?
we have already said that he is entitled to get the permission.
Wait.
This is our argument, my lord, he is entitled to the permission. There is some he has to furnish the document, the affidavit that has not been.
All those formalities are mentioned in the appeal court order.
No.
There is a direct direction that you shall revisit the pension payment order and ascertain the provisional pension within 2 weeks and say that same is paid. You have acted in blatant violation of this order. And where did the learned single judge consider this issue? Was the learned single judge apprised of this fact? Yes, Mr. Das. That any such order has been passed by the division bench. Is there any such direction?
I do not find it.
The court proceeded being oblivious of such direction. You did not point out to the single.
I have pointed out, I have annexed it.
Annex, where is the, you were there arguing, you are the arguing counsel.
Sorry.
Mr. Balailal Sahu is
Yes,
the,
I was there. I argued with him.
then did you,
Well, I have pointed out everything can be pointed out, but he is not reflected in the order.
no, judgment was delivered in front of you, 13th of January.
It was hard. And they are
It was made CAV. When?
it was last year hard on 5/2014, 2024. Judgment was delivered on
1/5.
2024.
Judgment was delivered on 13 January 26.
Yes.
Let me,
Only that matter was not everything at
don't say these things, Mr. Sahu.
1995.
1990.
Oh,
এই কার্তিক হেডমাস্টার ম্যানুয়ালটা দাও। হ্যাঁ, pages এখানে পুরোটা ভুল।
I have to go.
We will not return this.
Easy to handle.
Now, what had been the fate of the audit which was directed?
Yes. First, you are saying.
No, no, show us from the order. Show us from the order.
First, audit was, first auditor was appointed as per order of Justice Manta, page 2. That audit work was done in my presence. That the auditor had not validly submitted it. Now,
Come to
second time-
paragraph 8 of the judgment.
Yes, and
Your DI conducted hearing, you know.
GI director the authority resolve the issue.
Now, what was the direction? That audit will be completed within 4 weeks with assistance.
Page, chair, kindly come again, page 1. Kindly come page. Kindly come page 1. Yes. Your second come paragraph 17 of the judgment. Paragraph 17 of the judgment. Page 24. You have to read.
17.
17, paragraph 17. Have you not got it?
Yes.
Yes. LHD, in spite of being entrusted with the duty to conduct the audit one account period, respondents to the wedding further stated that according to the order dated 12 April 20, in this expedition, the school appointed auditors to conduct the report account of 2030. Respondents school has stated that though audit was completed, but auditor never submitted a report. Next, hence later on, another auditor, namely Laurka and company, has been audited to accomplish the said audit work by order of the director dated 13 September 2020. Audit of account of the school was done, completed from year 30. That submitted that first produce the report of the auditor by of subject. According to the said highlight, there is a defaultation of the subject, which is obtained from the job developer that care of the board required, therefore, according of on the basis of that, the data report has been.
So the audit report says that there is.
Yes, yes, all right. They have appointed, but when the audit was done, for the first time when the audit was done, as per order of the Supreme Court, I have participated, I have submitted all the documents.
So that auditor did not file any report.
No.
So thereafter another auditor was appointed. So the audit report is against you.
Against me, but that audit was conducted without issuing any notice, without giving any opportunity to participate. But in the first audit report, I have participated. And first report was.
So why did not the auditor did not file that report? That
because actually first audit report, I have submitted all the documents. First auditor did not file any. That is why here. And why the auditor was submitted? Why the auditor was appointed as per order of the Supreme Court? And second time.
Then you should have told the court that your order is not being complied with. Call the auditor. If an auditor is appointed, call the auditor and ask why he has not filed report.
That has been recorded in the order.
No, this fact has been recorded, but where is your contention that you asked the auditor? Your story is in that audit you produced all materials and the auditor was satisfied. and but auditor did not issue the report,
Yes, that is.
which would have been in your favor, Now the second audit report also you did not challenge.
But they have, how I shall be able to know that second time the audit report is there. During the
Audit
currency of the
report was
proceeding,
placed by a
that's why
supplementary evidence.
during the currency of the proceeding, they submitted the report by way of filing affidavit. By way of filing affidavit at the time.
Where is that report? Where is that second report which was filed by supplementary? Not annexed.
Not our opposition, not our opposition, our exception, our audit report, our supplementary, nothing has been proposed to annex it.
In referring the matter to the principal secretary.
Like the 1905.
There is no reference of the order passed by justice by the appeal court. No reference. So Mr. Das, today if we direct him to pay you this amount, there will be no problem in issuing no liability certificate because your problem is solved. We will ask him to pay to the school this amount, which you will keep invested in an interest bearing scheme. And we will call for all documents, audit report, everything, and thereafter decide finally. You make your argument if we find that yes, because Mr. Das, during his tenure, no disciplinary proceeding was there.
It is true.
So today, if we keep the matter for hearing, it will be very difficult for you to segregate this issue, that this proceeding you are conducting on the basis of an order of a court. Court said auditor appointed. He preferred went up in appeal, and appeal court said that do whatever you like, but give the provisional bench. Now today, strictly speaking, it will be very difficult for you to establish or to negate this issue that as there was no disciplinary proceeding pending against him at the time of retirement, you can withhold his no liability certificate. This is one aspect of the matter. Second aspect is that principal secretary has nothing to do in this matter.
Nothing.
So we will direct him to give you 5 lakhs such and such amount. You keep that in an interest bearing scheme, and we will finally decide the matter. If we find that there is defalcation, we will ask you to take that amount. And if we find there is no defalcation, then we will say that you return it to him.
Now, this appeal note for the allegation defalcation note that was made during the prior to 2017.
Doesn't matter, but you are not taking interest on that. Be happy to get that amount.
This is not my money, this is a money for the
So you
student.
are not
Naturally.
financial institution.
For the interest of.
You are not financial institution, you are not to earn interest.
Not at all, not at all. But this is the, practically this is the money for the minor student.
That is why we are giving it to you. That is why we are giving.
But
Because under the pension scheme, a person will be disentitled to get full pension if his service has not been approved by the competent authority. Here, service is an approved service. This not will never be resolved. You will shout that why you are not giving back. He will say, I will not give back. Consequences, school does not suffer, he suffers. Mr. Das, what will be the problem in disbursing the pension? Full pension.
account has your lordship. Last paragraph.
209 is the earlier appeal quota.
Appeal quota, sir, but class C is there as a fact. The institution where a official proceeding is the provision of question after accepting the order of the provision. Why not?
It is an interim order.
It's an interim
It is an interim order. Yes. You both of you consider that the criminal proceedings was instituted after return. At that time, there was a cessation of master servant relationship, and in the rule, the word issue has been instituted and continued. That means it indicates that has been instituted prior to return, and it is continued. Here, inter-institution was made after return.
But there is a strong
So the reason to withhold this benefit also not so strong. School authority, according to the rule, school authority could have initiated the proceedings much earlier. School authority and the state both have allowed him to return.
But there is
Allowed him to return without initiating any disciplinary proceeding. You will say that it was dated later.
So can you see?
Except this, you have no doubt.
Yes, yes. But that, as part of the rules, head of the institution is the custodian of all documents.
Or Mr. Sahu, you give back 5 lakhs, we will direct them to pay full pension.
But I am saying,
If you are minded to that, you do that. You will pay that amount, they will issue the no liability certificate, your pension will be disbursed on the basis. Where is that audit report? Second audit report, page? Wait, that has been annexed. Not annexed?
our document has not our opposition, our report, our supplementary, nothing has been given.
Ultimately, 5,49,000 and all.
47 something. 47 9.
No, no, we will dispose of the appeal. We will say, you will give that amount. You will pay that amount to the school. School will issue.
Capability to pay.
School,
Try to answer.
Secretary Treasury জমা দিতে হবে।
Treasury to-
Form 7.
Whether they will be happy, but they are interested for money. And I have talked with my client. If the amount is deducted, subject to without prejudice, let it be kept in the government fund. No, with the school, because of the school money. The amount to the line with the school is a separate matter and no problem.
It is the money of the state.
Audit report is not be separate.
It is the money of the state.
Money of the state to use by the school for the students.
School cannot claim that it is the personal property of the school.
Because this is a sponsored
Okay.
school.
Okay, it is the money of the state. State will take.
No, once the government allocate the school, this amount to be used for the school, for the minor student or for the institution, then it is the money of the school
Okay, you.
for the students.
No. School only dispose. Things before us.
Yes.
We will dispose of the stay application. But Mr. Das, formalities or no formalities, start this.
Fix a date, but yet proposal fix a date when the office of the PI. Yes. Both the petitioner as well as the present and the professional bench should be started.
Provisional measure you start.
Provisional measure you will start. What is the
But
necessity?
he has to take an affidavit that he is not anything, whether there is some formality. Formality will be compiled.
Formalities, if any formality, if there is,
What is the interest of this of GI? Only to harass.
no, his interest is by, in the appeal court order, there was no direction towards that effect. In the appeal court order, there was simply a direction for disbursement of family pension, provisional pension. You do it on the basis of that. Any signature or anything is required for that. No, no, if we say that, your directorate will again call him and keep him there for 10 minutes, 15 days. Unless you put the signature, go to High Court and tell. You do the needful. Because justice, in the earlier division bench judgment, there was a clear direction that
Everything is accounted for a single document that he has approached to the authority for releasing of the provisional pension.
How can-
From day one he is not cooperating. We are ready to, we open our argument for the learned citizens that he is entitled for the provisional pension. Even in the division bench, my first day argument is that, but from the day one he is not cooperating. School, what is his duty? You have to go back to the office and put in the signature and complete the formalities. But he is not at all interested. From the day one, there is a letters, various letters to resolve the issue between the parties. But that was
School authority and also the state authority has asked him to produce the bill.
well, that is separate issue. But from the professional
Produce the bill. It will amount to ask your accused to produce the document against him.
well, that is separate. But first, we have first pilot we direct to immediately resolve the issue. Well, now everything is online. Well, he has to put something. There has to be put
or if the school authority or the appellant sit together and settle the issue.
Repeatedly, we have tried to see, we have asked you, never you.
It is not the case, my lord. Actually, I went there, I
You
go and will unofficially give that amount to the school authorities.
But then,
No, why that is any sort of embarrassment occurs at a first last stage, it will be difficult. Yes, next 5. What? Yeah, defective application. Or defect. Or yeah, just 2 minutes. Yeah. So after mutual transfer, you made representation versus you were appointed on mutual transfer. Why? Why did the judge record? Come to the order.
No, that was appointed as a teacher subject to the physical education school or Sadhana or mutual case to Udahara from Coachbihar.
Are what on mutual transfer?
I was initially posted at Coachbihar ST. Here were therefrom I prayed for transfer. I was brought to
mutual transfer. You prayed for mutual transfer. And you was brought to Huda Hedempur High School. Now in Huda Hedempur High School, after arriving there, you made another application for transfer.
Here I am for about
Within how many days you made that application?
after about 7 days, about 7 years.
7 years.
Yes.
After joining Huda Hedempur.
Yes.
Acha, so then why it was why did the court say that the element of your parent is not acceptable?
That's what you're putting.
From Baharampur to you are going to Islam
I am asking
within the same district. You consider
we are Baharampur area.
whether every teacher is to be given appointment to
That was the
nearer to his
that was
the nearest to my residence.
that was the observation of the Honorable single bench. But Buddha had to from I mean Baharampur area.
Yes, Bora Bazaar.
I am requesting that in area in the Baharampur area. Buddha had to
Islampur, don't call.
it is a pure Islam for Islam for Rani.
So that transfer application you uploaded in Sushi.
Yes, the page 44.
Then what happened?
It was not considered where
It was an offline application.
no, Utsosi program.
Where do you have managed that?
I had stated, but it was not assessed.
Now, indicate.
That we have seen.
Document the million is forwarded to DI. Very good. From DI থেকে recommended for transfer. School service. এটা হচ্ছে 2021 24. This is for Huda.
পোর্টাল থেকে বার করুন।
Then why it is not being given? It was recommended for transfer.
Yes, that was recommended, madam, but ultimately it was not given effect. Therefore, you
Why,
might-
why?
that one they have not disclosed. You will kindly look at page 44.
44.
That was an application.
আমার বলে application. Yes, Mr. Mukherjee, why? What
You are for the commission.
For the state.
state? কি হলো?
Who is for the commission of board?
Board has nothing to do. Where is this commission?
Commission, who is for the commission? Have you served?
No, commission, I have some state.
আচ্ছা বলিও state কে serve করেছে commission.
We have to bring commission. Commission.
Respondent number 4 you have served.
Commissioner have knowledge. I have some
আরে
state.
তো সেই তো করবে. It is recommended by the DI. DI has recommended your case to the commission
Yes.
and it is kept pending from 2021. Why the commission has not
party.
taken steps?
Commission is not party.
Commission is party. Commission is party.
Respondent number 4.
Normally state.
West Bengal here. Respondent number 4.
Now, Mr. Mustafa, if your petition was recommended by the DI, then what did you do from 21 to 24?
Thereafter,
Hey, Mr. Mito, that's
that found in the name Mr. Suresh,
okay.
in the single case.
তাতে কি হয়েছে? আচ্ছা, লেখো হার্ড মিস্টার মুস্তাফা learned advocate appearing for the appellant and Mr. Mukherjee learned
Item number 3, Alphabet. But this is the civil certificate. Which is not already set up. The matter can be resolved. Subsequent development has taken place. Alternative arrangement has come to this group. Now the division is there is a development.
Then you withdraw the approval.
Actually, not by the division. But after the alternative arrangement has come, the DI has not informed. The role of the DI is to count the DI is sent to the commission for passing the recommendation. DI has not sent it to the commission. So, by the time DI could say transfer application of the division to the commission, take the further consequential steps. That is why arrangement has been made.
Where is that copy?
I have added it.
Acha, what was the order of the
That billing picture was 1.7.
Now it is submitted.
Now it has been done. Go with not billing, but PI has made it. Possible. Paragraph 7 must be.
so you are the person to be transferred.
Obtain transfer single subject picture. The billing picture not came in this order. My child the billing picture lost the same that billing picture is not. Now an alternative arrangement in terms of third general institution has
Now the head of the institution is not releasing that person.
PI is to first send it to the commission. Commission will issue recommendation, then arrangement. The alternative feature has already joined us. But I am
Has joined.
already joined. When you see the record, I have attended.
Which one? This one.
This one is
Has been placed to render his service.
temporarily has been from
Then what happened?
what it has been the teacher has joined. I have not been released.
That who was the person joined? Shamol Kumar Karo. Acha, he has joined.
He has joined.
So now the DI has to
Send it to the commission. Commission will
send it to, where is that circular taken? Show that portion, what is the duty of the commission?
yes, but that is the recommendation. Relevant portion is that page 93.
93.
Last paragraph.
Yes, where in the single digit DI shall you discuss the when we take urgent steps so that the such DI shall will inform the DI shall inform such arrangement to the commissioner.
Notification shall inform the matter to the chairman of commission, president of the board, and supervision department. CSC will ensure that such arrangement in 7 days. Immediately, the DI will communicate such arrangement to the department and the inquiries. Forward the application to the DI. DI will then forward the case to the SSC.
এটা হয়েছে।
Will recommend the case for consideration.
So we will say we will record your fact and we'll ask the I ask the district inspector and commissioner to take all follow-up steps in terms of this.
Forward it to the commission.
In terms of the notification that will solve your problem.
Kindly might mention to the commission that this will create another problem for the follow-up step.
Is a the specific DI will inform such arrangement to the commissioner who shall inform the matter to the president of the board. তারপরে CSE will ensure who is CSE, then
DI will communicate such arrangement to the school
Concern and the
and DIC shall forward the West Bengal Court Service Commission for consideration. Consideration will suitably recommend this case for
commission is to reach to the commission.
the DI and the commission will take all follow-up steps. Then your purpose is served.
You have to send it to the commission.
No, we are not quoting that. We are saying follow-up steps in terms of the notification will be taken by the state and the commission in terms of this notification. Where is the order impugn?
Page 122. The first page. See, here just same thing to all the, this was not to the commission. The 9 September.
We will direct that. We are directing that. The order impugn We understand, madam. We are helpless. Tell us how can we protect? Supreme Court says 21. Prior to 24. She disposed of. I think 20. Huh? Supreme Court was 9th April 25. And
Division bench order,
July 2024.
July 2024.
In our division bench.
The husband of the petitioner died in 2021.
then how did he?
These services also.
No,
So why
commission
the-
recommend.
The right has already been crystallized.
He was appointed on 16. Entire pattern has appointment cancelled.
No, by that time, chairman commission issued a memo of 22nd January 20.
That time this appointment was very much there. Because
No, 25 January 25. When was Boishaki disposed of? Subsequent date too.
3rd April 2025 by the Supreme Court. July as in July 2024. But the right has been crystallized since commission has recommended. Commission has already recommended.
but thereafter this thing started to loss. Maybe it was made, but thereafter it was found that this is 16.
There is an order of the Supreme Court, madam. That Rekha or something that had been appointed.
In 2024. She was in service now.
Maybe
You could not have touched her record.
that I don't know, madam.
And due to delay caused by you, now the agency.
Where is the commission recommendation?
Uh,
ওই ছেলেটা নেই এখানে রাকেশ সিং। You call Mr. Singh, commission who appears, you know him? Uh-huh.
Recommendation is January 25 by the commission.
Yeah.
After the panel, the intern appointment was cancelled by a division. Our division of justice for sure. The intern appointment was cancelled in the month of July. Thereafter, it traveled to or after prolonged hearing, the final order was passed in April.
No, had he been an untainted teacher, if he was an untainted teacher,
That Mr. Singh can.
wait, untainted teacher was given a consequential right that you appear in the next SNST. So that direction, you call, নামটা কি ছেলেটার? Get hold of Rahul Singh, ask him to compilation আছে।
It's a great deal of, I'll inform Mr. Singh and other.
Then are you cancelling the pension orders which have been issued to the widows? Then what state? Apply your mind, madam. Suppose I was an untainted teacher. I lost my job. Before losing my job, I expired. My wife started getting family pension. Then you will have to stop family pension also, because I have one person who has died. Would have been his appointment would have been cancelled had Boishaki been delivered by that time.
Are you receiving family pension? You are receiving family pension. Oh,
এবার ওটা বন্ধ করুন। Now he will stop.
No. If he's untainted candidate, he could have got back the job also. Why you are saying that everything cancel and you are taking advantage of that? Untainted candidate has been given an opportunity to reappear in the examination held in 2025, and the successful candidate would be given appointment, although process is not complete as yet.
Untainted candidates will given that they will contribute.
Continue up to August 2026 most. Now, if the untainted candidate becomes successful in 2025 examination, they will again be appointed. So why you are treating that?
Ms. Bhattacharya, you in fact have nothing to say in this matter.
Okay, Mr. Singh can say whether he is untainted.
Sometimes be a bit sympathetic, madam. Don't go by the stricture of the statute. You are an advocate of High Court, Calcutta High Court. Don't have this mindset that I am bored, I will oppose. Go to home. No, this attitude should not be there. You are pointing it out that had he been alive, my lord, Supreme Court order is there, Boishaki is there, confirmed by Supreme Court. That is your argument. That had he been alive, a person died, family pension started, compassionate appointment given by you. Now you say had he been alive, so he is suffering the punishment of his husband who has died. You have to apply your mind.
Okay, can you say that whether your husband's name was tainted list or untainted list?
You collect those copies. You the untainted, tainted list you collect. Whether your husband's name was there, get yourself prepared. This argument you have to advance. You have not taken grounds to that effect. If you want us to do something, you have to put the material.
It is with Mr. Singh.
Singh and with Ms. Bhattacharya, both specialists.
It is with also you. It is not with you.
সব জানি।
Mr. Singh, you go and collect from Mr. Singh.
Why you have added commission as a party? Commission is a respondent.
Commission is the recommend person.
You should have added them also.
And your recommendation has been made commission. You have not made commission as party. Commission is with you.
Half-hearted attempt. Yes, you have appointed chairman commission is there. Regional School Service Commission?
Eh?
কি হলো?
So in the,
Service complete.
Yes.
bring your friend in the battle first.
Affidavit of service as that he will not oppose, not he will oppose. So you oh, achha. So you are not, so you have no such feeling about my brother, huh? আসো তুমি ঘুরে পরের ম্যাটারে দেখছি। Yes. এই তপন এই তুমি
still of me.
have you brought Sudeep Chatterjee? বলে দিলাম last day I told you.
There is no post or procedure taken physically.
No post.
Only two posts are available. One constitution, one physically. According to the staff pattern, one maybe procedure. Second is physical. But if the schedules, then post has to be given.
No. Staff pattern says language and science and everything will be 50%.
I know.
But in physical education, I think there is no.
Rules, holders shall be limited to the 50%.
That is for science group and language group, I think.
No,
Where is 4th September circular?
what's the thing?
Yes, that's the
First, high school, junior school. And then
Where is work education and physical education?
they must study one episode of 1990.
98 memo, where is it? আপনি এগুলো ইনস্ট্রাকশন নিয়ে আসুন। Where is our judgment? Mr. Acharya, you have to go through it. You have to find out that line.
So there is two teacher now in work education and physical education group in the school. And he is claiming one person is receiving a postgraduate scale or master degree scale.
No, on a decision subpattern, the school has certified.
Is there two teachers in work education, physical education?
One remain vacant from the very beginning.
Very good.
Of course, they do not have other qualification, they are not getting under the postgraduate scale. What are you trying to do?
Okay. Staff pattern, give us staff pattern. A certificate of teacher. 100% is a staff pattern.
Subpattern of 23, not when you was appointed.
2003 years, their date of appointment, whether they have retired, 2003 it is. No, 5th April 2026, the headmaster has signed. Two teachers, Sadananda Pal and Devika Chattopadhyay.
They appointed in 1983 and 1997.
Exactly same case. Exactly Pradeep Mishra's same case. Kindly come to page paragraph 4. This is what we wanted to know from you, Mr. Acharya. This was the submission. 10 lines from the top. On the date Pradeep was approved as work education, 4 lines from the top. On the day Pradeep was approved as work education physical, the revision of pay and allowances rules which provided was operative, 98 operative, which would be inter alia that a teacher would be entitled to higher scale of pay according to his or her qualification. Such higher qualified teacher in the relevant subject or group is justified as per approved staff pattern of the school. In the order of the DI on 3rd August 20, it has already been found Pradeep at the material time was second teacher and the other teacher was not having postgraduate qualification. This you have to satisfy.
No, kindly have a look.
Mr. Mukherjee, you are saying that the person who is working in the 2 persons are there in the
2003. Because he entered into the pool of the so it's not
very good.
2003 staff pattern and 2003.
Very good. 2003 staff pattern which you are saying. In this decision, we have held that we have given him the benefit because in Utpal Kanti Karan, it said that relevant circulars will follow.
Yes.
So we decided that issue. Please take it down, Mr. Acharya, that Chatterjee judgment is required. Sudeep ki naam hai na.
Sadananda Pal, BSc Honors Math,
Check it up, na this.
who is before us?
আমাদের উজ্জ্বল বাড়ি।
By the school certification, the
Ujjwal Kumar Marti. What is the name of Ujjwal Kumar Marti? পোস্টারটা কি নিয়েছে কবেকার? You are not serious.
kindly have a
Where is Ujjwal Kumar Marti in this part in work education group? What is the name of Ujjwal Kumar Marti?
serial number 20.
Sadananda Pal already retired on
And I appointed my lord in 2003, 19 February 2003, column number 7.
Then where is your name in the staff pattern? So this staff pattern has been signed on 5th of April 26. then your name has to be substituted there.
But this was at that material point of time when I joined, whether this was the staff pattern. Now the question is, out of two teachers, none of them is.
Acha, where from you are saying these things, Mr. Acharya? Staff pattern নিয়ে এসছেন,
The current staff pattern you would not have produced, you would not be able to produce current staff pattern.
Let the DI consider it. Kindly have a look on 100-point roster, hereby our mind assessment was given.
So go to
Place of
Then go to DI.
Go to DI, the school shall, DI shall take decision after giving an opportunity to you and to the school authority.
In what aspect, Malal, I am putting this. Considering the staff pattern.
Staff pattern, question of staff pattern is to be considered. We given that opportunity.
This is the staff pattern. But I have ended up.
Current staff pattern continue a name and qualification. And name of other teacher, qualification, date of appointment.
But this was there, right?
No, you saw the name of Marjit.
Yes, kindly see. Kindly see right hand side. Kindly see last 9 and 10. See, Ujjwal Kumar Marti, BA, BG. 40. 19th February 2003.
Is it staff pattern?
Yes, 100 point roster.
100-point roster
Yes.
vacancy.
100-point roster is
Your junior is not aware what is staff pattern. It is 100-point roster.
in the
Or maintaining which post will be reserved for SC or ST or which post will be
Yes,
continued.
in place of Sadananda, I was appointed there. But this is not.
We want this information as on date. How many teachers are there in work education and physical education group? And what is their present qualification? We wanted this information only. Otherwise, court has asked you to go to the DI. You go.
But this, one I had I have just seen you. This is to certify that as to staff pattern of one.
Mr. Acharya, that document was not there before the report. So we will observe this and send it to your DI. That this circular is there, and there is a judgment which you have placed reliance that if one of the teachers is having a undergraduate scale, then there can be, you are permissible, your case is permissible.
That will be better. Let us have we shall produce all the documents. Sadananda Pal আর দেবে আমার ব্যাকে পুরোনোটা now register here
26 years,
Sadanand Pal
there are 100 point, এদের বলাতে এটা করছে or maintaining 100% transfers that subsequent determine the appointment of
উজ্জ্বল কুমার মার্জি তো বলতে চাইছে উজ্জ্বল কুমার মার্জি has been appointed in place of Sadanand Pal.
General examiner.
দেবিকা চট্টোপাধ্যায়.
Yes, general examiner.
দেবিকা চট্টোপাধ্যায় B.Ed, not B.P.Ed.
তাহলে তো স্কুল পেতেই পারে।
DI consider. Let DI consider it.
One of these certificate, my lord, dated 7th of April 2026, clearly said it is the certificate of the school. Well, it says Sadananda BSc, honors in maths, physical study, and to Srimati Devika Chattopadhyay, PhD.
বলছে come to the order of the DI. DI has rejected your case on the basis of this 4th September.
By the Honorable Secretary. His order was set aside by the Honorable Secretary.
We will reimpose that condition. That will be good for you. When you are Mr. Acharya, we have given you how much time, tell us?
Yes, no doubt.
Huh? You didn't even prepare a supplementary evidence. So let me go with these documents. School is not appearing. Mr. Mukherjee may oppose. It is his duty to oppose.
Yes.
So if you don't take care of your own exercise, what we can do? We 3 times granted you adjourn. 3 times. That if it is a genuine case, all right, let us finish it today. You are not doing it. As my brother says, you go and satisfy them.
You are making such an observation. He shall consider, keeping in mind that the decision principle laid down in Utpal Kanti Court as well as our observation. Ultimately, it is the DI who will give.
Yes.
Court will not give. We shall not.
No. What, my lord, I cannot pray the statement.
Okay.
The impugned order which was, my lord, set
Yes.
aside, my respectful submission before your lordship, my lord, when the impugned order has been set aside.
Under what proposition we will interfere? Can you show us anything, law? That it having set aside upon just as we remand. When we remand, we set aside that direction. Court has said revisit. So you show us something that in is a genuine, it is an accepted case. There is no necessity of the court to send it back to DI. That is your argument, na? He has to meet that argument.
Physical education সবই pass. There is no different category. Keeping in mind and keeping ratio decided in the techniques.
My lord,
Vaishali,
no, it is a single decision of the same.
You facts are not clear. You are going for decision.
No,
In course of hearing, Mr. Acharya under না বাড়ি চলে যাচ্ছি।
madam, next madam.
আমরা থাকছি না তো বাড়ি
Next madam.
নেক্সট ম্যাটার we are coming
Bye.
Mr. Bhattacharya is appearing. Huh?
The respondent will,
Hmm?
which will appear for the respondent.
Oh,
Respondent did petition.
But I am for the petitioner appellant. I am for the appellant. And really it is the preliminary point taken by the appellant before the learned single judge that falls for your lordship's consideration first. And that is why your lordships were pleased to fix it today for my submission on the preliminary point of locus standi. Sure.
Yes.
Lord, before I place my case, I'll just indicate in a few sentences what really is the point taken. Number one, who can question any order in a writ proceeding? The law, if I may put it that way, has been settled by your lordships.
Mr. Sengupta,
Yes, my lord.
the appeal is heard. No issue. You argue on merits.
Lord,
We'll
your lordship's,
definitely.
your lordship's pleasure was to say on the other day that no, we will hear the preliminary point first. Because
No,
if the,
you argue the preliminary point. If we are not satisfied, we will continue with the hearing of the
oh,
appeal.
then yes, certainly. Certainly.
Yes, tell us.
Lord, who can file a writ petition? A person who is affected. And Lord, in the writ petition it is mentioned being agreed by and dissatisfied with such and such. The petitioners beg to move this court on the ground as follows. So he has to be aggrieved by and dissatisfied with something which he is challenging in the writ
Yes.
court. Number two things. What is the subject matter of challenge? Kindly come to the writ petition. Page 1 it starts.
What one appeal has been, you are appearing in which appeal?
I am appearing in MAT number 2171.
And who is in the other appeal?
Mr. Joydeep Kaur, assisted by Mr. Vishwarup Bhattacharya.
Where are they?
On the
So we will wait for you. On your direction, we have fixed the matter at 2 p.m. Huh? How do you treat the court to be? Your seniors were there. They heard it is fixed today. And you're giving an excuse?
I have not paid for an accommodation.
Then what you are exactly trying? Who will argue for the appellants? Call him just now. Yes.
But if you also sees the prayer in the writ petition, first,
writ petition says prayer is at page 21. A writ of or in the nature of mandamus to issue commanding the respondents, their agents, servants, etc., to provide your petitioners with their original OMR.
Which is the page of the writ petition prayer?
21.
Which is the page number?
Volume 1, page 21.
Which volume 1? There is a paper book.
Yes.
Paper book to the 171 এর paper book to the Yes, you continue, Mr. Sengupta.
Yes. The prayer at page 21 says a writ offered in the nature of mandamus commanding such and such person to provide your petitioners with their original OMR sheets as submitted by the petitioners in respect of the first state level selection test 2016 for the post of assistant teachers in upper primary level in the subject of physical education, along with the answer key and the respective questions. Kindly mark one thing here. What they are asking for? OMR sheets of the state level selection test 2016. And when is this prayer being made? Kindly see. It's affirmed on November 2022. So, that your lordship will get at page 24, I believe. 25. It's affirmed on 15th day of November 2022.
Who are you?
My right appointment has been questioned. And
please tell us the facts. You were successful candidates.
Successful placed in the wait list, not in the selection list.
This is pertaining to which selection?
This is the selection to assistant teachers in primary level in the subject of physical education and work education.
Very good. So you participated, you have secured position in the wait list.
I have secured the position in the wait list.
Yes.
But the petitioners who are before the writ court, they say kindly come to paragraph.
So you were the respondents in the writ petition.
I was on my own initiative added. I was not made a party.
So how many persons you are representing? All the appellants in 2171?
But 2171.
Very good.
Yeah. No, appellant is one in 2171. I am representing 200 and odd persons who were added by the writ court.
200 and odd persons. You were the interveners or you were added
Yes.
as parties?
Yes.
You were
Added
added
as parties. Added as parties.
Filed an application which was allowed and we became.
Filed CAN 2 intervention application which was allowed.
Our application.
Your
Ready.
additional party was allowed. Now
Yes.
tell us, you are wait-listed candidates. Now what is the status of the petitioners?
They kindly go to tell the page 8, paragraph 4. Your petitioners state that your petitioners, being eligible candidates, had participated in the selection process. This is the first thing. Had participated in the selection process in the subject of work education, duly appeared in the written examination, and gave the same with utmost satisfaction. Whose satisfaction, I do not know. Must be their satisfaction. But to their utter dismay, they were not called for verification and the personality test. Kindly pause here for a moment. When does the cause of action arise? 2016.
Just Sengupta, you argue on merits. We are 16 paper books. We cannot segregate. What is your merit? You tell us.
Lord, so far as preliminary point is concerned, your lordship will not be troubled with.
No, we will decide both the points together. Both the points together. You
Lord,
tell us.
my lord, my respect was your lordship will not have to deal with so many paper books. Volume 1 will do for the preliminary point. Only volume 1 will do. I do not have to.
Suppose we are not with you. Then what we will do? We will fix another day.
In any event, if we
You
go
are-
to in any event, if we go to merits, it cannot be finished today.
Maintainability point, segregation, first a decision on that, then the merits. This
My lord,
compartmentalization may not help. You know, the matters will never be answered.
my
Then
lord, this matter went to another appeal court when the learned single judge did not grant our prayer, and the division bench, presided over by Justice Sen, held that the preliminary point is to be decided first.
was that order? Which is that order?
Yes.
Volume 9, page 1186.
Volume 9,
Now we can say volume 9. Volume 9.
page 1186.
So there were two appeals. So you have to show both the appeal court orders. So this is the first appeal of 2023.
Calcutta 1901, maintainability.
That is 1946. Yes.
There was one initial order when the court said, court has not passed any order, we will not interfere now.
Allow us to go through it.
Yes, not.
There is single.
So page 1186 and the second one is at page 19.
It's the notes filed by the petitioners.
Volume 9.
All right.
What was the decision of the only bench?
Volume 9. Volume
Yes,
15.
but then matter went back, but the learned judge having not decided the preliminary issue and saying this will be heard together, not matter was again taken to appeal. That order is, your lords will kindly get.
In the order which you have shown us, where is it said that you determine the main?
Yes.
Where is that?
Kindly come to page
So these are the issues involved.
1946.
Now, whether this issue is identical with the issue in the matter pending before the Honorable Supreme Court or not?
No.
What is the determination of by the single bench?
I
In comparison with this order.
Lord, so far as Learned Single Bench's order is concerned, certainly I shall place before your Lordship what is there. Because if your Lordships are satisfied with that, then Lord,
That is totally separate issue.
So you show us how the single judge has dealt with this.
but before just 1 minute, Lord, kindly see the division bench judgment. There,
Where we don't find that it has been kept open or it has been relegated for consideration of issues involved in the writ petition, whether the issues in the writ petition and specially petition are identical or incident.
page 1950, kindly come to that. Same volume.
1950.
Now,
1040.
জীবনে শেষ হবে 1950.
yes. Kindly come to paragraph 12. Upon hearing,
Wait, we have not yet opened it.
oh, I'm sorry, I'm very sorry.
Nine, 6. Paragraph
12.
Huh?
Paragraph 12 at page 1950.
Yes, place it.
Upon hearing the learned counsel for the parties, it appears that locus standi of the writ petitioners have been seriously disputed. It is straight law that if a question of locus standi is raised, that issue being fundamental and jurisdictional needs to be decided first before any interim order could be passed. Now, interim order was passed, ex parte, because we are not there, only the petitioners.
That is his lordship's observation. Where is the
No.
direction that you decide?
Kindly see. For to claim any such relief, the argument that the writ petitioners are unsuccessful and hence they cannot maintain the writ petitioner is a matter of substance and requires considerations at the threshold and only upon a prima facie view being formed and other requirements of an interim order are fulfilled, the court can pass an interim order. If your lordship is pleased to come to page 1952.
Give us 2 minutes.
Yes, Lord, yes, Lord. One 1952, paragraph 15, last 8 lines from the bottom.
We have a question, Mr. Sengupta.
Yes, Lord.
The order of 1st of December 2023 says
Yes.
Your grievance is that the issues involved in the writ petition are in no way involved in this SLP.
Yes. And that has been established after the appeal was dismissed. Yes.
Had the learned single judge in the order of 30th November 22 directed the Advocate General to ascertain whether the issue under consideration the writ petition is incidental and or collateral and issue before the Supreme Court. Where is this decision? Where is the return of finding by the court on this issue?
On this issue, the state had filed an affidavit
Think that both the issues are different.
Yes, both the issues are totally different.
Then where is the decision of the single judge pertaining to this argument of yours?
Yes, Lord. Kindly come to the learned single judge's decision.
Oh, in the order impugn it has been decided.
Yes.
It has been decided in the order impugn.
Yes.
That because this is that proceeding which resulted in the setting aside of the 26,000 candidates, the appointments of 26,000 persons, followed by
But it has nothing to do with that.
But
There's no point in confusing things. There is
an attempt was made to confuse this issue with that issue through several means. But finally, it was clarified by Honorable Justice Khanna's judgment, which clearly.
So what ultimately what was held in the writ petition?
Well, as far as our main contention was on locus, because if you are
where is the decision on that issue?
yes. Locus paragraph judgment.
Wait, karo 1478.
One 1542. The 1542.
Volume 13.
Yes, it starts from 1480. Yes. Tell us that portion where this point was considered. Paragraph.
Yeah.
Ascertain হয়ে যায় that Shankar Prasad or Sandip Prasad, matter of Shankar Prasad or Sandip Prasad.
Sandeep.
And Sandip Prasad. So those issues are different.
Absolutely.
So if the same issue is pending before the Supreme Court, so we should not go into that.
Show us the paragraph from which it
Lord,
will quote.
Your Lordship kindly sees. Good.
Page number still. Page number.
1665 is the finding of the learned single judge on this question.
Which paragraph?
1665.
পরের ভলিউম দাও আবার। এরকম ভাবে মামলা করা যায়? You have comfortable.
Take the judges will go. You have asked that one issue is also pending in the Supreme Court, so the appeal court remanded the matter back to the single judge to decide whether the issue involved in this matter and the issue involved in the Shankar Prasad, Sandip Prasad matter are identical or not. So you just have to satisfy this point first, then we go into wherever you will take us, we shall go. You just satisfy this first point. Yes.
But I'm grateful to your lordship that this is the precise point we have been harping.
Page. Which page you are saying?
1665.
1665.
Yes.
Yes, 5. It is 66. Oh, okay.
Oh, yes. 1665 middle. A. The court on the first issue. My lords have kindly got it.
Yes. One 1665.
21.
The Honorable Supreme Court, in the case of Dharanidhar Mishra,
কি তিনি অ্যাসিস্ট করছেন ওনাকে বার করে দেওয়া হচ্ছে বারবার মিটিং থেকে ওই জন্য স্যার বুঝতে পারছেন না
Yes.
the Honorable Supreme Court, in the case of Dharanidhar Mishra, cited on behalf of the petitioners, has observed that in a case where demand for justice is so compelling, a constitutional court would exercise its jurisdiction with a view to promote justice and not to defeat it. So, does it amount to saying that whether you have locus standi or not, court will entertain?
বুঝতে পারছেন
আমাদের ব্যাপারটা উনি আমাদের ব্যাপারটা দেখতে পারেন আমরা যেটা জানতে চাইছি ওটা শুনতে পাইনি বা যা হোক কিছু হয়েছে ওরা জানে জায়গাটা
But am I audible to all lordships?
Yes.
Now, if your lordship says paragraph 21, the court on the first issue, that is begging the question. Because it doesn't say, this judgment doesn't say, that even if a party does not have locus standi, they can come to writ court and the writ court should interfere with a view to promote justice.
একটা জিনিস দেখিয়ে দিচ্ছি ইস্যুটা আমি বাদ বলছি জাস্ট গিভ মি এক সেকেন্ড
Kindly see paragraph 6 and 12. These are the two issues that the court framed, and court only answered these two issues. The main writ petition is pending. Court has framed only two issues, one at page paragraph 6 of the judgment, the other is at page paragraph 12 of the judgment. The rest of the writ petition has been kept pending.
Paragraph 6. Then we have to go again back to another page.
Paragraph 6 means volume 1 that your lordship was. Here. Another page, paragraph 6 of this judgment.
Yes.
All the arguments are noted, and ultimately, the court has really not answered the question.
Paragraph 6 and
Paragraph 12, Lord, your lordships will find
paragraph 12 is at what page?
paragraph internal page 16. Internal page 16. Your lordships will find the marking, Lord, at the bottom of the page.
অ্যাকচুয়ালি যেটা উনি খুলেছিলেন ওখান থেকে দেখেন
Lord, paragraph 6 at page 1627.
1627 para 6 para 12
Para 12 to page.
Whether the petitioners, being unsuccessful candidates of the relevant selection test,
So,
are
paragraph 12 issue is not what Mr. Sengupta is telling us.
paragraph 6, I say.
You only want to know. Page 1186, court said that whether the grievance of Mr. Sengupta is that his clients are different and no way involved in the SLP.
That issue has not been addressed in the impugned judgment.
Not addressed.
That main writ petition has been kept pending. Only these two issues have been taken. Am I clear to your lordship?
স্যার এটা এই ইস্যুটা আসতেই পারে না
The
because
order
the-
by which it was relegated for consideration, you mean to say that issue has not been considered?
that issue actually cannot arise.
Has not been considered.
So you are appearing for whom?
But for some of the candidates,
So
I'm
you are similarly placed with Mr.
as Mr. Sengupta.
Identically placed.
I will really adopt the argument which is ultimately advanced by Mr. Sengupta, but Lord, factually,
Now, Mr. Sengupta says that it has been addressed by the court.
subject to correction, Lord, I feel these are the two issues raised by the court and the court, Lord, only disposed of these two issues. Because if your Lordship sees the penultimate paragraph, where Lord, the court says the rest of the writ petition will stand to trial.
So that means that it has gone against you.
That
If
means,
the
that
writ
means that-
petition is survived, traversing from the appeal court order of relegation that decide the point of maintainability, court without, you mean to say that without deciding that, court said the writ petition is.
absolutely. Kindly, Lord, your Lordship will kindly, Lord, Mr.
So
Sengupta,
two issues were taken up for
and
consideration.
these are the two issues which is decided. Rest
So whether the first issue is whether the petitioners being unsuccessful are entitled to challenge, and whether the accommodation of the applicants in waitlisted kind of supernumerary post.
That's another aspect.
That's the other aspect on which the court has addressed. These are the two issues only picked up from the entire writ petition. And this is,
So
as
where is this issue one, and then none of the said issue is the issue of which you want adjudication.
Lord, we also want adjudication on these two issues, which is
No, Mr. Sengupta says, I don't know whether you are accepting that contention, that don't go into the merits of the matter. When it started, you were not present, Mr. Gaudu. We said that allow us to go into the merits and finish it up. But Mr. Sengupta says that when a coordinate bench has directed the maintainability point to be decided, so you have to consider that.
that is one of the submissions. But Lord,
Now, if it is not addressed, we will relegate the matter for addressing that issue. What more? That will further delay your case.
let Mr. Sengupta, Lord, I'm holding him up. Kindly let him complete his submissions. Then, Lord,
No, won't it be advantageous to us if Mr. Sengupta and Mr. Kaur sits together and sets the point which is to be argued, and we understand, take the advantage of that
of course,
argument.
it's always a pleasure to sit with him. There is no difficulty.
This could have been done in the meantime, Mr.
I thought I'll adopt his argument. That is the reason, Lord,
No, his argument and your argument is poles apart.
No,
He
no.
said that
no.
against.
No. Perhaps, Lord, I have not been able to
No. What we understood is Mr. Sengupta says that this issue has been erroneously decided. Your contention is that it has not been decided. Only two issues.
Not erroneously decided means, Lord, if non-consideration is an erroneous decision, then Lord, I have to say it is erroneously decided because some point was urged.
What is your argument, Mr. Sengupta? That point has been considered by the judge in the order. This
But
which you have urged, that whether your case and SLP are same or not.
no,
This has-
no,
So that has not been decided.
no.
So then your argument should be subject to correction, that when a coordinate appellate bench has relegated for consideration of this point and you have not considered this point, you have not considered this, then the entire appeal needs to be relegated again,
But only one thing.
and the interim order
Who
will
is-
continue.
Or the state.
No.
Who is for the
appearing for
state?
some of
We
the
are coming
Appealing
for-
for whom?
some of the applicants. I'm indicating it to your lot.
No, whom you are appealing
For
for?
some of the appellants here.
In which matter?
Not in one of the appeals.
Alleged reason, para 20.
There are only two appeals before us.
Clear.
There are only two appeals before us.
17, item number 17.
Give your appeal number.
FMA 74. FMA 74.
FMA 74.
Next.
This
72
question,
তো আমাদের নেই
74.
74 is there.
Yes.
74
Mr. Joydeep Kaur is my leader.
yes, then
Not only with his permission, may I just, that's the query that is falling from your lordship. There is a query which is falling from your lordships, that whether Shondip Prasad and this issue is same.
Yes.
My answer to your lordship is answered in serial paragraph number 1 of the judgment under appeal. The notification here is a completely different notification pertaining to selection of work education and physical education teachers. No other teacher. 9, 10, Group C, Group D, nothing. Only, it is a selection initiated for filling up posts for work education and physical education teachers. This selection process, was never challenged. It was challenged at some stage. The challenge was failed. The challenge failed. In your lordship's court, that judgment and order is also a part of the paper books. That challenge failed. No appeal carried therefrom. Now, what happened is the government in its prudence has come up at a decision to give some preference or a leeway, if I may say so, to the waitlisted candidates of that selection process. That selection process, first, kindly keeps this in mind. That selection process is not covered by.
very good. So you place para 1 and you place the coordinate bench judgment which set at rest this issue as you are submitting.
The coordinate bench, this selection was never a part of that selection.
No, you said no.
That again I am repeating, maybe I have not been able to explain it to your lordship. This judgment does not in any way affect or touch the issue of Boishakhi Bhattacharjee, Shondip Prasad, or whatever those appeals. It has never touched, because that's a different selection process.
Shondip Prasad was also similar to
Boishakhi, yes. Boishakhi covers, Boishakhi covers SLST class 11, 12, SLST class 9, 10, SLST C and D. These are the 4 groups covered in Group C, Group D.
SLST 9 and 10, SLST 10 and 11,
and RLST, C and D.
C and D, 4.
Groups, 4
yes,
groups.
Yes.
4 groups covered by Boishakhi. Justice Boshak's judgment covers that. Justice Boshak had no occasion to touch this selection. Nothing.
No, in the notification itself, it is said excluding work education, physical education.
Yes, in the notification. Correct. Then, in the notification that was published here, the notification which triggered this entire process, initiation is by a notification restricting it to a selection of work education and physical education teachers. Am I clear to your lordship? It has got now. This notification is the notification which covers this entire process. And what happens is,
in the selection process, you had been the
waitlisted candidates. And these persons,
and who are the writ petitioners?
The writ petitioners are unsuccessful candidates.
Writ
petitioners did not sail through.
They were not called for
zone of waitlist.
Now, what interim order has been passed?
The interim order that has been passed, the waitlisted candidates, with both my seniors' permission, the waitlisted candidates, where the government arrived at a decision to give them,
to accommodate
these
by creating
candidates in certain supernumerary posts.
Yes.
Show us that interim order.
Yes. The initial interim order.
That is to create supernumerary.
Yes. Please come. It is a decision of 19th May 2022, page
299 of the paper book. Volume 3.
তোমাদের না পেপার গুলো এখানে বের করে রাখো। আচ্ছা, why couldn't you make a substantive paper? 299 is a notification.
Yes.
299 is a notification.
Yes, sir.
It's order.
Cabinet decision.
I think this is the interim order.
No,
just supernumerary order.
Yes. Interim order চাইছেন। এই 19 May ডকুমেন্টটা চাইছি।
রিডিং অর্ডারটা কোথায়?
My lord, only one thing, my lord, your lordships.
Sir,
This
we
is
are
the-
thoroughly puzzled. Please take your seat.
Milord,
Let us
Milord,
try to fathom what
take
is
these
the problem.
compilations in FMA 74. It is a part of this compilation. বলো compilation এর part থেকে বলো।
এটা কি পেপার বুকের আছে?
হ্যাঁ, পেপার বইয়েও আছে। It is there.
ঠিক আছে।
Volume 9, page
Please.
3.
Page 3 and 4 of that document. Kindly takes this. Of volume 3. আচ্ছা তো তোমার কাছে? তুমি বলছো বলে দিলে তুমি। হ্যাঁ, 19 মে। আচ্ছা তো। Milord, this is a decision. Milord, may, Milord, sir, of course আছে, 9299. Filling up of supernumerary posts. My lord very kindly got it. Page 3 and 4 of that. 3 and 4.
compilation.
Milord, I have handed over a compilation on in connection with FMA 74. Circulate করে দেবো সবাইকে।
Yes, 3 and.
দিয়েছো? সুদীপ্তকে দাওনি?
দেয়নি, আমাকে তো পেপার বুক দিয়েছে।
So this memo has been stayed.
Yes. This decision, this was 19th May 2022. This decision, Milord, kindly sees what is the decision. We are covered by A2, creation and filling up of 1600 supernumerary posts of assistant teachers with breakup of 750 and 850. Milord, 2, we are only concerned with 2. Am I clear to your lordship? Not the other part. The other part covers the first selection process, the other selection process.
That's right.
For which, Milord, an inquiry was directed and inquiry was stayed.
অর্ডারটা কোথায়?
So
19
Sir, this one. Page 299.
Now what?
So this notification has not been considered by the Honorable Supreme Court.
No, this
Any of them at-
I indicate to your lordship. This notification was brought to the notice of the division bench, the other division bench which heard Boishakhi. This notification, so far as this creation and concern and cabinet decision, Milord, they were put to task. A CBI inquiry was directed. The honorable division bench, the bigger division, the other matter, Milord, the SLST matter. This notification, so far as one is concerned, 5261 posts.
there is no observation pertaining to B in
B,
the
in
Boishakhi
the,
judge?
no, it cannot be because B is not a part of that process. Let's work education, physical education has been challenged. The challenge failed.
These people, you people are waitlisted candidates.
Yes. And
So what was the compulsion to accommodate you by creating supernumerary
that is
posts?
the issue which has been answered by the honorable single judge in their favor. The writ petitioners, our case is, as my learned seniors were pointing out, that the writ
No,
petitioners,
that
despite being
was-
unsuccessful, did not have the locus to challenge. I'm sorry.
No, that we understood, but this this point B, this is pertaining to creation of supernumerary posts for the purpose of absorbing waitlisted
persons,
candidates
yes.
like you. Why this compulsion arose? That
Page
waitlisted-
11 kindly see. Please see page 11 of the compilation. Please see page 11 of the compilation. Compilation টা আমাদের airdrop ওখানে airdrop হবে? Compilation টা আছে?
No, the original panel has been, persons have been appointed. from the
Yes, original
original
person appointed,
which you are waitlisted.
in which we are waitlisted. The original panel has been appointed. The panel exhausted. The panel was challenged. The challenge failed. These persons are all working.
Very good. Now, why? What was the compulsion of the government to create post
That
to
answer is
accommodate?
perhaps not there in page 11. Kindly see.
But in fact, if I may interrupt,
Working.
the Supreme
You
Court
are saying that the a Roman one was the subject matter of Boisaki's matter.
Roman
Yes.
was subject matter to a limited extent in
Boisaki. So what Supreme Court says
me, my senior team.
regarding
I have made myself clear.
Kindly see the Supreme Court order. This clarity will come. Kindly see the Supreme Court order in that compilation. Look, it is in page 34.
30 is a division bench order.
34. Rikta Sarkar.
This is a division bench order.
Second volume.
Supreme Court order to do.
Well, 34 of the compilation.
Compilation we are seeing. 34.
কি আমাকেই যা দিচ্ছ
34 is the order passed
The division bench
in Rikta Sarkar matter.
অন্য কিছু ডকুমেন্ট আছে দেখো
পেজটা বলো সুপ্রিম কোর্ট হচ্ছে যে সুপ্রিম কোর্ট অর্ডারটা পেজটা কত এইটা করতে গিয়ে আরো রিটেন নোটস আছে অর্ডারটা আমি দেখাবো অর্ডারটা এটা দেখাবো কি বলছিস Supreme Court order directly clear by them.
That is in the additional paperwork filed by them. That is page 34 of that. Filed by them, yes.
There's an
Additional creation of supernumerary সেটা তাই করুন
সিচুয়েশনটা কি দাঁড়াবে আমার সুপারনিউমারি পোস্ট সমস্যা হয়ে গেছে
The 252.
or we understand this there are two separate components. One is for the 9, 10, etc., etc. Yours is apparently it seems it is different.
And the Lordship will get that clarity from the Supreme Court.
No, right,
Just
right.
one paragraph
No,
of
yeah,
that
but let us understand. Now you are saying now the single judge has decided two issues. Pertaining issue is numerary post creation was bad. Against that you have come up in appeal. Argument is that today you decide that if the writ petition at all was not maintainable, then the other decision of creation cannot, that order also will go. So it is inextricably bound. How can we segregate and decide your maintainability? We have to say that writ petition is maintainable, so the other finding goes automatically.
That is our contention. My lord is absolutely right. That if the repetition maintainability issue was gone into, then Lord, with all these points would not have come. Maintainability has not been decided at all. The court Lord picked up two issues. Lord, as your Lordship knows, it's under order 14. If a preliminary issue has to be decided, they have to be favorable to maintainability, etc. Lord, here the court Lord only decides two issues. One is Lord, the creation of supernumerary, and the other is appointment in the supernumerary.
No, the first issue, as you showed us, was
Yes.
paragraph 6.
Hmm.
Whether the unsuccessful are entitled to challenge the notification. But this issue has not been decided, you are saying.
Decided, this issue has been decided. Your Lordship kindly sees the findings so far as this issue is concerned.
That is at which page?
Paragraph 21 onwards, your Lordship will find.
21 page 1665. Volume 13.
ये पूछते बड़ा very difficult.
No, paragraphs, you are on compilation.
No, the main judgment.
Yes, main judgment, paragraph
166.
The first issue.
Paragraph 21. 1665. Yes.
internal page.
Internal page 40.
There the discussion starts.
Yes.
From the first issue.
Yeah. Yes.
Page 1665 of
1665,
volume
internal
13.
page 43.
Yes.
volume 30.
Then where is the finding of the court to answer? Ultimately, what did the court say?
Period 1666. Kindly see. Page 1666, paragraph 23. If the said test is applied, the issue of maintainability vis-a-vis the locus standi of the petitioners cannot be decided at the threshold as a preliminary issue.
I am at one that is that to decide the issue of maintainability. So it has been decided.
No, kindly see, the petitioners cannot be decided at the threshold.
Yes.
Now, if I may be permitted to put the question in this way to myself, the division bench felt that a decision has to be taken on the question of this. And the other just says, maintainability still of vis-a-vis locus standi cannot be decided at the threshold as a preliminary issue.
Because for that the amendments in the writ petition
Yes, I go by that. I go by that. I did not show to your lordship any other document. I have placed only the writ petition.
To decide the issue raised by the respondents, the amendments made in the writ must be taken to be true and correct. You have not
Definitely.
cause for that. You have not come for that. That
No,
it is true. You are
but
in the amendments in the writ petition.
I say, in view of the amendments in the writ petition, paragraph 8,
Relying upon the word.
it goes. Wait one. So paragraph 8 is a part of the writ petition.
বুঝলে?
Yes. Now, your main contention is that unsuccessful candidates cannot be treated as a person aggrieved.
Yes. That's
It is,
the
and hence they cannot be treated as a person aggrieved. They have no locus to maintain an action or file a writ petition. It is your main contention. Court says that the here issue of corruption, manipulation, etc. was raised,
It is not a public interest litigation.
and hence inter panel was challenged, inter selection was challenged. So this issue cannot be stated to be a single out, to be a issue based on question of law, and should be thrown out at the threshold. It is a mixed question of fact and law.
My lord, may I be permitted to make this a very respectful submission?
Yes.
Question is, writ petition is to be taken to be sacrosanct. Let us put it.
Hmm.
On what subject you can make your statement? If paragraph 8 says
Hmm.
that we are unsuccessful candidates,
Hmm.
that means you are out of the reckoning.
They have challenged that action.
No.
They have challenged that we are unsuccessful because of the fact that some manipulation was there, some irregularity or illegality were there, and hence we are unsuccessful. You are giving a certificate or seal to unsuccessful candidate. So that the matter has been decided. Whether they has been rightly declared as a unsuccessful, that is under consideration. So long this matter is under consideration before a court of law, so an action taken by so-called unsuccessful candidate can be thrown out on the stating on the ground that you have no locus.
Not may I submit? Yes, it can be thrown out and should be thrown out because of this reason. A 2016 selection is being questioned in 2022.
If there is fraud, the court has to look into it, Mr. Sen.
Question is, Lord, who can allege a fraud? Who can allege a fraud? It is not a, kindly remember, it is not a public interest litigation. If had it been a public interest litigation,
Who has suffered injury on account of that fraud? Who can allege a fraud means who has suffered injury on account of that fraud.
Yes.
So if the entire selection is done by resorting to some illegality or such irregularity, so the selection made or the candidate came out to be successful candidate or unsuccessful candidate shall have a right to challenge the same.
Because selection is not under challenge.
And since they have rather challenge, they shall have a locus.
Which is not their case here. In fact, the fact that they are.
Who are you, sir?
My lord,
You are for?
I am assisting Mr.
I mean, successful candidate.
Hey, have sir mercy on us. We are first listening to Mr. Sengupta. Then his junior comes
I
and says,
apologize. I apologize.
But only one thing, subject to correction by your lordships.
Hmm.
The selection panel has not been questioned.
You have the query of my brother, Mr. Sengupta.
Yes, Lord.
Brother has put you a question.
Yes, Lord.
Give an answer to that. Suppose I am an unsuccessful candidate.
Yes.
I don't have any material today to say that the selection process in which I have been declared unsuccessful is totally bad. There is fraud has been practiced, etc. Now I come after 2 years, I get some documents. I cannot come to read court and say that this entire process is a fraudulent process. You listen to me.
Your lordship is absolutely right.
Not that we have to go into the genuinity of the statements made by the writ petitioners.
But the only thing is,
we cannot throw them out like this, Mr. Sengupta. My brother's query is, today you are saying public interest litigation, very good. When there is a large scale fraud, and there had been such a fraud in the earlier process pertaining to the teachers. So you will say that you close your eyes just now, whatever they have said that is bullshit. You just declared that they are unsuccessful, you go.
no, that's not my submission. Lord, that's not my submission. Lord, possibly.
Your selection, correct us if you are wrong. Your argument is they have not challenged the selection. They did not challenge the selection process contemporaneously. They came up
also
in period of time. First, the select list has not been challenged. The select list itself has not been challenged. And you cannot allow them to even show to you that these are things which is to be taken into consideration. That is why paragraph 23, the single judge observes that I am with Mr. Bhattacharjee that to decide the issue of maintainability, the averments made in the writ petition must be taken to be true and correct.
But here I just add one sentence for your lordship's kind consideration. It
Yes.
has to be treated as true and correct. But I am on a fundamental question. Who can put that question? Who can put that question? Any busybody.
No, he was the participants of that selection process.
That's true. Participant.
It is not that he has no connection with the selection process. One
But
day
kindly-
he has come. He cannot be termed as a busybody. He was a participation. And he has challenged his selection. He is asking that, show me my OMR sheet.
Mr. Sengupta, come to the next paragraph, paragraph 24. The Honorable Division Bench in Mat such and such, while affirming the order of injunction passed by the court, had never directed that the said issue is required to be heard first, deferring the decision on merit.
Lord, your lordship has seen the appeal court judgment.
So, appeal court judgment, we said that this is the proposition of law, that when you are maintainability raised, you should address the said issue. This is a well accepted principle. But where is the order of the division bench that without deciding the point of maintainability you cannot go? You decide it first. Show us that line, we allow your appeal.
Milord, as it came from your lordship, that if I allow your appeal, it has to go back. Then, Lord, we are in deep trouble.
That is another aspect. That is,
Yes.
that is a question of irreparable loss. You
Yes.
are saying, I think,
Mr. Sengupta,
Yes.
you know very well, under Order 41, Rule 2, preliminary issue is framed.
Yes.
Preliminary issue, when based on pure question of law, it can be decided at the threshold.
Yes.
But preliminary question where question of fact is also involved, then the court will go further
Yes.
to find out. So here question is not only based on question of law, that you cannot be treated as a person aggrieved. He is coming claiming that some illegality has been committed, and thereby we have been deprived of.
yes, Mr.
We
Sengupta,
could have been included in the listed candidate.
Acha, Mr. Sengupta, please take us back to the coordinate bench order where you said that the division bench said that decide the point of maintainability first.
Yes.
Only show that paragraph vis-a-vis paragraph 24 of the judgment.
Lord.
You said na division bench judgment.
Yes.
You told us that
Yes, certainly. Paragraph 15 and 17. Having regard to the fact that the waitlisted candidates are waiting for almost 2 years now, and they would otherwise be entitled to appointment as waitlisted candidates on creation of supernumerary post. But for the challenge, we would request the learned single judge.
Mr. Sengupta, we have not got the order. 1st December 2023 order you are reading.
This is order
20th May 2020.
20th May 2025.
Page 1953.
Which page?
1946.
Page 1946 and page 1952.
20th of May 2023.
2025.
Yes, 25.
That is at page
1946, volume 16.
1946. Wait. Volume 16. এটা নয় 10, 11, 12, 13 ভলিউম 16 টা দেখো তো বাবা এখানেই আছে ওটা এই যে 16 yes volume 16 page 1946
Yes.
yes Mr. Sengupta, which paragraph you are reading?
two paragraph, paragraph 15 and 17.
Para 15 and 17. Yes.
Paragraph 15 deals with this question that if a prima facie case has been made out for interfering with a
Yeah.
cabinet decision,
We
is
are asking your junior to place that paragraph. Yes, read.
Pilot paragraph 15. In so far as the decision of the Honorable Supreme Court is concerned, it is clear that the direction for investigation by CBI with regard to creation of supernumerary posts pursuant to the cabinet decision was set aside. The justification of the state in creating the supernumerary post in exercise of power in terms of clause 2 to article 74 and clause 3 to article 163 of the Constitution of India is being challenged in the writ petition. However, the essential question requires to be decided is at whose instance the said challenge is thrown. Moreover, if prima facie case has been made out for interfering with the cabinet decision, it is also been seen to be considered.
So where is it is to be decided
So,
first?
my lord, now paragraph 17, having regard to the fact that the waitlisted candidates are waiting for almost 2 years now, and they would otherwise be entitled to appointment. Waitlisted candidates, as in us, our clients, to appointment as waitlisted candidate on creation of supernumerary post. But for the challenge to the notification dated 19th May 2022, we would request the learned judge to decide the said issue as expeditiously as possible.
Then what are the you are saying said issue means the issue of locus. But the court kindly come to para 15 again.
Yes,
Insofar as the decision of Supreme Court is concerned, it is clear that the direction for CBI with regard to numerary posts pursuant to the was set aside.
yes.
The justification of the state in creating the supernumerary post of India is being challenged in the writ petition. You have to read the paragraph together. Where is the segregation? That no, don't go into the issue of creation of supernumerary post.
Yes.
You decide the point of maintenance.
So because the
Acha, show your argument which you advanced.
because I'll just show that from the notes, my lord. If my lord kindly takes the question that has been formed in paragraph 15. The question is, however, the essential question requires to be decided is at whose instance? Whose instance the said
Yes.
challenge is thrown.
We are
And
also
then
not.
paragraph 17 refers to this question.
Paragraph 70, read paragraph 70, what's the said?
Said issue.
Yeah.
It says
Said
said
issue.
You
Said
cannot
issue means
pick up
something
a
said
single-
prior to that sentence. Said means something said prior to that sentence. So if you ask the conjoined reading to read conjointly, paragraph 15 and paragraph 17, then two issue comes. So who can throw this challenge and whether creation of supernumerary post is correct or not.
You show us your argument before division bench that you decide. My argument is you decide the maintainability point first.
Yes, my lord. That is
Yes.
there in the notes.
No. From the order itself. From the order itself, Mr. Sengupta has argued paragraph 7. What is the argument? Sengupta has submitted the present have no locus to maintain. Sengupta submitted applications of the decision. The appellants are to be considered for appointment as they are waitlisted, for which supernumerary posts have been created by the state. So Mr. Sengupta has argued both the issues.
Yes.
Both the issues have been, these two issues have been, Mr. Sengupta's argument contains two things. One, locus standi, and second is whether this issue of supernumerary post.
But
these two has been answered in paragraph 12,
Volume
like,
13.
paragraph 15 and 17.
13.
Sorry.
my lord, paragraph 21 onwards, when in the impugned order, when the learned judge addresses the issue, he addresses the issue of maintainability. First, he says that I cannot go into the maintainability question, and then he decides against it. So, my lord,
No, that is your, the judge, the order says, ultimately what is the decision of the court? That I cannot decide the point of maintainability without going into the merit of the awardments made in the deed.
And hence decides that they have the locus.
Naturally, because they have ultimately gone into the records and court said that the supernumerary post was different.
But my lord,
My lord, may I just try to assist your lordship in this way? My lord, your lordship is perfectly justified in observing that there are 2 points, but only interdependencies. First point is with regard to locus standi, and the second point is with regard to supernumerary post. Now, who can question the creation of supernumerary post is the subject matter. That's the first point. That is why we say if the first point is accepted as we put, the second point does not arise.
Judge Supreme.
Nothing. Sir, it's on mute. The court is on mute.
Mr. Senugta, you have any other argument on
Yes,
this?
sir. The test of locus standi has been held to be whether you are going to be benefited by the order that you are praying for. If you are not going to be benefited by the order you are praying for, then you have no locus standi. Now, as I submit to your lordship, the order has been passed. has any of the writ petitioners got any benefit out of it? If no one has got any benefit out of it, then such persons cannot be said to have a locus standi. I'm grateful to my Honorable Justice Chakraborty that yes, it can't be said to be a busybody. True. True. Well, two Chakrabortys being there, I have to.
No, no, no. We are, though we are both.
Yes.
Therefore, how you are going to be benefited by the order that you pray for is a test of locus standi.
Yes.
And in that sense, he was a busybody because he is not going to be benefited in any manner. And that will be corroborated by the fact that after the order has been passed, no one of the applicants, writ petitioners, has got any benefit.
All right. Yes.
Only thing is, my clients, who are the waitlisted candidates, they have suffered because they were given the recommendation letters.
We understand. What is your next point, Mr. Sengupta? Any further argument on the locus, Mr. Sengupta?
My lord, about locus, I have, my lord, two submissions to make. Two submissions to make.
Yes.
One is, my lord, I shall place the division bench judgment of our High Court in this regard, where in an insurance company, selection was going on. Now, a batch of persons who were unsuccessful challenged that. And one learned single judge of our High Court said, no, this is absolutely an illegal thing that has been done. Therefore, the appointments are set aside. Lord, those aggrieved referred it an appeal. I had the privilege of arguing this case before the appeal court, consisting of Justice M.M. Dutt and Justice G.N. Ray. And their lordships were pleased to all look here. A judgment has been delivered. How are you going to be benefited? We have not been benefited in any manner.
But the citation, judgment which Mr.
Lord, I shall give, my lord.
All right. Yes, give us anything else, Mr. Sengupta?
Lord, so far as locus standi is concerned, I must try to dispel any doubt that is in your lordship's mind. In my own humble.
Let us hear the other side on this point, and then we will, in reply, we will take your reply.
As your lordship, as your lordship.
Please for the writ petitioner.
I am for the writ petitioner, my lord. At the very outset, my lord, on the
Petitioners in both the appeals, Mr. Das.
yes, my lord, only one writ petition.
Eh?
The court is going to argue the other appeal, item number 70.
No, maintainability, Mr. Cord will
Yes, everybody
told us that point, Mr. Cord said. Mr. Cord also adopted. He said, I am adopting the submissions of Mr. Sengupta. That Mr. Yes, Mr. Das.
My lord, only one thing before I start, my lord. In this appeal, my lord, there is two appeals where they are initially added. Thereafter, they are at the state and the commission who oppose us before the single bench, both on the maintainability and they heard also on merit. My lord, since we are the writ petitioners, my lord, let the state only because after all if proceed with my submissions, my lord. Thereafter, state and commission again say these points because they are also, they oppose us.
They will never come. We have to,
My lord, they are here, my lord. They are here.
No, that is commission. The advocate general has to be heard.
Advocate general was also
So who is for the state. Now adjournment will be taken. My
This is
advocate
the-
general.
Is online.
Huh?
The learned AG is online.
Where is he? Yes. Yes, Mr. Dotto.
That is. Phone karo.
And this is the difficulty. And secondly, my lord, on the very
Now,
first
what
day,
is the difficulty that if state some stay, how will
But-
you be benefited?
not benefited, my lord, since they are arguing against in supporting the appellants, my lord, because they argued in support of the applicants, my lord, before the learned single judge, my lord. Again, my lord, before the appellant here, after all,
You argue, what is your point? You argue now. We will hear the argument. Yes.
thereafter again we have to give reply to their argument.
But
This is-
why? There is no respondent will not have to give any reply.
my lord, then if the respondents do not argue on
Then
maintenance,
we can never finish this matter.
my lord,
Let
another
us
thing, my
finish
lord, another thing, my lord, I must point out before your lordship, on the very first day I submitted, since this matter is being fixed, my lord, it was made to understand, my lord, maybe it was my fault, my lord, that Mr. Lanet Senior, Mr. Sengupta and Mr. Korvila, because since I am being led by Mr. Bhattacharya, I submitted on the first occasion also Mr. Bhattacharya was present.
No, we have heard them. You please tell us what.
My lord, we filed this writ petition, my lord, in 2022, and the selection was, appointments were made in 2018, panel expired in 2019.
You filed the writ petition
in
in
2022.
Hmm.
But appointments were made in 2018, 2019, and panel expired in 2019 December. Admittedly, commission in its affidavit has stated so. So, my lord, once panel has
it expired when?
December 2019, my lord. The date, my lord, I am supplying to your lordship.
Yes.
December 2019. Thereafter, my lord, suddenly your lordship remember a matter when your lordship was sitting in the division bench, a matter came up before your lordship against, my lord, this creation of against creation of supernumerary post. My lord, when these 9-10 SLST matters were going on, my lord, during these matters were going on in 2022, that is in May 2022, my lord, the state framed this, took a cabinet decision, and my lord passed the order of 19th May, that is creation of supernumerary post. My lord, it was pointed before the learned single judge.
19th May
2022.
This is the memo. Memo of creation.
My lord, that was challenged before the single bench, which bench was hearing the SLST that 9, 10, 11, 12 matters. My lord, on seeing that, my lord, and a affidavit of the commission was placed also before that bench to accommodate illegal appointments, supernumerary post has been created. This is on record and application of the School Service Commission. My lord, seeing that, the learned single judge stayed the operation of that 19th May and directed the secretary of the school education department to come up with the file as to what prompted this creation of supernumerary post. And my lord, the learned
That is in
single
a
judge,
separate writ petition.
my lord,
Is in a separate writ petition.
no, my lord,
Yes.
My lord,
No. These are in connection
no,
with.
my lord, I tell your lordship why. The memo is a single memo of 19th May, including 9, 10, 11, 12, physical education and work education.
Memo is yes.
My lord, what happened thereafter? The single bench said that this memo cannot be given effect to and directed the secretary to be present personally with all the files. My lord, an appeal was preferred before your lordship in a division bench, my lord, by the state as well as the commission. Your lordship upheld the order of the single bench. My lord, against that, your lordship in the initially was talking about that Sandeep Prasad SLP. against your lordship's order passed in Sandeep Prasad that the supernumerary post, the secretary should
That Sandeep Prasad was included in the bunch of matters which
He-
were taken by the single judge.
My lord, it is thereafter. I am coming.
On the Prasad matter.
Sandeep Prasad appeal was against your lordship's order. That is a separate appeal which was filed by the state and the commission. And my lord, this Boishaki Bhattacharya matter, which was heard by the division bench, that was on the legality of the appointments of 9, 10, 11, 12. That was separate, and that Sandeep Prasad appeal, my lord, before the Supreme Court was regard to your lordship's order that supernumerary post for creation of
But our
accommodating
order
illegal
was set
appointments.
aside.
My lord, no. That was, my lord, taken up together. All those appeals, my lord, were taken up together
Before the Supreme Court.
before the Supreme Court. The Supreme Court initially first, my lord, on 3rd April's order, set aside all the appointments. Thereafter, my lord, on 8th of April, on the issue of the division bench directed that there shall be an investigation to be conducted by the CBI. Why? As to against those person, against the cabinet, which took the decision of creating supernumerary post. My lord, there the Supreme Court said, no investigation can be carried against the persons against the cabinet rather who have directed for creating the supernumerary post. But my lord, whether the state can at all create the supernumerary post was kept open. My lord, now in why I came up in 2022, immediately on 19th.
No, then our judgment
was
upholding
affirmed.
the single benches
was affirmed.
was affirmed.
Was affirmed. My lord, thereafter what happened?
Direction for CBI inquiry.
No, my lord. Which happened?
That
Sandeep Prasad.
we delivered the judgment.
Yes, my lord. Your lordship upheld the judgment that there should be a CBI investigation, and the secretary of the school education department was to appear personally before the single bench.
Then what happened?
My lord, initially the Supreme Court stayed that appearance.
Stayed our order.
No, stayed the appearance of the secretary of the school education department.
But the order was not touched.
Order
Then
was
what
not
happened?
touched. Ultimately, my lord, the Supreme Court in Boishaki Bhattacharya directed that CBI will not investigate against the cabinet who took the decision
For creation of
supernumerary post. But the order creating the supernumerary post, whether state has the power, my lord, was not interfered. It was kept open for the single bench to decide. Now,
single bench means before who?
My lord, this matter was pending from 2022. Challenging this 19th May order, my lord. After this 19th May order was passed, we the writ petitioners, my lord, approached this honorable court saying that we participated, we were not given the Weimar sheets, and there are this. And
have you stated all these things in your writ petition? Give us the paragraph numbers of your writ petition.
My lord, the writ petition.
So Supreme Court took note of the pendency of the present writ petition.
My lord, that was in when we initially filed the writ petition, there was no Supreme Court pending. After filing of the writ petition, my lord, this Boishaki Bhattacharya and everything happened.
We are concerned with the Sandeep Prasad.
My lord, Sandeep Prasad.
Sandeep Prasad decision, you stated that whether cabinet can take decision, that would be decided by the.
No, that was decided in Boishaki Supra, Boishaki Bhattacharya. Because ultimately, my lord, the division bench, while deciding Boishaki Bhattacharya, also directed the cabinet, the CBI should investigate as to how the cabinet decided to accommodate illegal appointments by creating supernumerary posts. This in Boishaki Bhattacharya, our division bench decided that, directed investigation. So, my lord, it went before the Supreme Court, state and everybody filed. The Supreme Court decided the CBI will not look into the cabinet the validity of the supernumerary memo was kept open.
Now you just regarding locus standi.
Yes.
Now, as per the Mr. Sengupta's submission, that one person can file a petition who is aggrieved. That means we are suffered injury by the action or inaction of any administrative authority or executive. Now, Mr. Sengupta has gone a little bit further. He has said that who can get benefit if this order of creation of supernumerary posts is set aside, whether you will get benefit. So on one hand, you didn't suffer, according to Mr. Sengupta, you didn't suffer any injury. So according to him, you cannot be treated as a person aggrieved. And on one hand, even this order is set aside, you will not get any benefit.
Yes,
what is your answer to this?
My lord, your lordship knows maintainability is one thing and entertainability is another thing. My lord, what I have learned from your lordships and your lordships.
You have brought that judgment.
My lord, this is has also been decided in Boishaki Supra by our division bench. It is, I don't know whether it is.
Yes, that is there.
That is there, my lord. I will place that, my lord. Why I am doing so? My lord, rejection of plaintiff, if I take from the clue of Order 7, Rule 11, there are certain grounds on which a plaintiff can be rejected. My lord. On those grounds, any of those grounds, my lord, are not there. On facts, if I have understood correctly, Mr. Sengupta is stating on facts, I am unsuccessful. I am not going to get any benefit. For that, my lord, it requires the court, my lord, to go into the merits of the case. Then only the court can come to a conclusion that whether I am unsuccessful or not, whether I will gain some benefit or not. From, my lord, and for that reason, my lord, a petition may be maintainable. But ultimately, it is found that I am not entitled to the relief. But for being not maintainable, Order 7, Rule 11, those grounds are to be said that it is not maintainable on those points, my lord, under Order 7, Rule 11. It is not the case. If, my lord, the pleadings are whatever pleadings have taken out in the writ petition, my lord, for holding that a writ is not maintainable, even if it is taken that my writ, all the pleadings are taken to be gospel truth, my lord, and they are right, even if those things, a petition is not maintainable in law, that is not the case. My lord, that has been decided by the impugned order, that if the allegations that have been made in the writ petition,
which paragraph?
My lord, in the impugned order,
taken to be true at their face value.
Then, my lord, the point of the writ petition has to be entertained for deciding with the correctness of the pleading.
All right. What is your next point?
My lord, this is my first point. Second, my lord,
whether you can challenge the cabinet decision.
My lord, then it is on the merit, my lord. Then I have to, my lord, whether what advantage I have gained.
No, what is your explanation to paragraph 15 and 17?
Division bench has said you have not challenged.
You have not,
because the division bench.
However, the essential question required to be decided is at whose stand the said challenge is thrown.
My lord, why the appeal was preferred before the division bench, that has to be seen first. My lord, an interim order was given in 2022, which was subsisting. My lord, suddenly, since the matter was adjourned by the single bench on the ground that it was pending before the Supreme Court, and in the Supreme Court order, my lord, presently, my lord, on 7th May 2025, it is being recorded in the Supreme Court order that it is the submission of the state. My lord, presently, I don't have that order. State submitted before the Supreme Court that we are not going to give any appointment to in the supernumerary post, naming our writ petition number, that the writ petition is pending before the single bench and there is a stay. So we are not going to give any appointment. So kindly stay the order of CBI investigation. That was the specific submission of the state. Considering that submission that it is state.
In which matter?
My lord, in Boishaki matter. This writ petition was referred.
Now, then Boishaki matter, that judgment has been finally decided.
No, my lord. Before it was finally decided, on
3rd of April 2025.
yes, that was finally decided. Before that, on 7th of May 2025, when the Honorable Supreme Court took up Boishaki's matter for passing any interim order or not, it was submitted by the
It
state.
was disposed of in April, I suppose.
My lord, April 23rd of 7th of May, my lord, 2024.
I see, I
7th
see.
of May 2024.
Huh.
It was taken up by the Honorable Supreme Court, my lord, for deciding the interim order whether CBI will continue with the investigation of the cabinet against the cabinet. My lord, when that matter was taken up, it was submitted by the state that a matter challenging the cabinet decision, that is our writ petition, my lord, is
No,
pending.
why did that point arise that Supreme Court was asked that action be taken against the cabinet?
Yes.
This was not the subject matter in Boishaki.
Yes, yes, that was also the subject matter in Boishaki.
That was also the subject
Yes,
matter.
it was decided by the division bench in Boishaki Bhattacharya, my lord, that this creation of supernumerary posts is absolutely.
But that is pertaining to 9, 10 and
Yes, that
C
is
post,
pertaining
not
to.
pertaining to this.
But the memo is same, my lord, but it was considered only in respect of 9, 10, 11. And
Achha, in course of hearing, the state submitted that we are not going to appoint any
give any
person.
appointment, and the matter challenging the validity of the that memo is pending before the High Court.
That's very good. Now, ultimately,
Yes, my lord, ultimately
Boishaki,
what happened? Ultimately, when the single bench was hearing this matter, my lord,
Boishaki ended.
Boishaki ended, and this matter was being heard by the single bench. My
Yes.
lord, while hearing the single bench matter, we found
Now, you said that that issue may be considered by the High Court. That is which is
yes,
that is
being-
which order? Say April, May.
No, my lord, final order. That Boishaki final order.
In Boishaki final order, it was said that CBI will continue with
No,
the.
CBI will not continue. CBI investigation was set aside. CBI cannot investigate the decision taken by the cabinet. 8 April order.
Supernumerary post.
My lord, what happened during hearing of the matter before the single bench, this matter, my lord, I pointed out that, my lord, the interim order has expired. Kindly extend the interim order. My lord, a point was taken by Mr. Sengupta and the other respondents that an interim order is initially subsisting, it has expired, so it cannot be extended. My lord, I filed an application for extension of interim order. That extension of interim order was heard out, and my lord decided that since the matter was here and it should be extended till the disposal of the writ petition. From that order, my lord, the appeal, my lord, that paragraph 1516, that appeal was preferred.
Paragraph 1516
of my lord, which your lordship was referring, of Justice Showmanson's division.
Oh, I see.
From that order,
that order means a reinstatement of interim order.
Extension of interim.
Very good. It was reinstated and extended.
Reinstated and extended. Challenging that, my lord,
he went to Justice Sen.
They went to Justice Sen.
Achha.
My lord, what was, and before Justice Sen, my lord, they argued not only that it cannot be extended, they argued that supernumerary is valid, they argued the maintainability, everything. What the division bench, my respectful submission on going through the, my lord, division bench order, my respectful understanding is, my lord, the division bench said, since these persons are awaiting, let the entire issue, my lord, means
no, not the entire, said issue.
Said issue, my lord, said has to be decided, my lord, on the basis of the foregoing paragraphs.
Now, where from do you say? We say said issue means which is included in this paragraph.
Not only included.
Say we have left this point to be decided. Said issue.
My lord, said issue means the issue which has been decided in the earlier paragraphs, the issue which has been dealt with in the earlier paragraphs refers to the said issue, my lord.
Said issues, not said issue, not issues.
Yes, said issue. The issue is the writ petition is the issue.
Connotation ought to have been said issues as argued.
My lord, said issue. What is the issue argued, my lord? The issue
maintainability. Maintainability.
No, my lord, not only maintainability. My lord, may I go through,
we have read it.
Order?
No, maintainability. Huh? Hmm. Acha, any other point you want to address? That your point is that these issues were
Inexplicably bound.
these arguments were made. These were those
Question of
issues
fact.
were left to be decided. Yes. What is
My
your
lord,
next argument?
What? How am I prejudiced by this? Because it is maintained. How am I aggrieved? And what benefit I have got? My lord, the School Service Commission rules 2016 for appointment of physical education, work education, there is a separate rule. My lord, rule 8 of that rule specifically stipulates the vacancies and the manner of calling the candidates for interview. Whoever participates, my lord, will not be called for interview. My lord, there is a process. Since this work education and physical education, there is no giving TET is not required. So, my lord, suppose the rule says, suppose there are 100 vacancies. Then, my lord, 140
In
candidates.
physical work education, no TET is required.
My lord,
in physical education, work
No
education, no TET required.
My lord, suppose there are 100 vacancies. 140 candidates are required to be called for interview. So, my lord, we all participated. We did not come for within those 140 according to the ratio. So, my lord, we were not called for interview. A panel, those candidates who fall under those 140, my lord, were called for interview. These, my lord, applicants were also within those 140. A panel was prepared. The panel was given effect to, and the panel expired in 2019, December 2019.
So you were not called for interview since in the written test you did not.
No, there is no, my lord.
What is the procedure?
That is, my lord, if there are 100 vacancies, 140 candidates are to be called in. That means in the ratio of 1:1.4. So I was not, there is a, suppose, my lord, 10 is
as per the vacancies, you did not come within that.
Within this. So, my lord,
Now, what is the procedure? Then there is a written test. This panel, this one for 100, 140 candidates are called. These are the 140 means the persons who applied. Oh,
and
there is
sort
no
of the
screening.
basis of academics and everything, thereafter the final merit list.
No, there is no screening for calling in the interview. 7 except 1 is to 1.4. No, that is not the view.
My lord, probably that manner of selection, rule 7, my lord, I am reading.
Yes.
Selection to the post of teacher except physical and work, this is not, my lord, thereafter. Manner of selection. Selection to the post of teacher except physical education and work education shall be made category-wise on the basis of merit weightage of TET, academic, and qualification and marks obtained in personality test in the manner specified in Part A of Schedule 3.
Personality test. So you appeared in the person.
No. Personality test is thereafter. My lord, personality test is thereafter. My lord, thereafter sub-rule 2. Selection to the post of teacher in physical education and work education shall be made on the basis of the result of the written examination. In the written examination conducted by the Central Commission. Evaluation of academic score.
There you participated in the written test. Then you did not come within the zone of 1:4.
Yes.
So you are not called.
I was not called. So, my lord, written examination, not only written examination, after written examination, evaluation of academic score.
Yes.
So, my lord, suppose evaluation of academic score and written examination, I got 40. Let us take a case. But on 1:4 consideration, the cutoff was 45. So, I did not come with it. I was not called for the personality test.
So, you are unsuccessful.
Here, my lord, on based of that, my lord, a panel was prepared. A panel was prepared, a waiting list was prepared. The panel was exhausted. All appointments were given, vacancies were exhausted. There was no vacancies. And the panel expired on 19th of December 2019. And my lord, the rule says under no circumstances the panel cannot be extended. The rule says. Thereafter, my lord, in 2022, suddenly the state or the commission framed this, my lord, 19th May 2022, creating supernumerary posts. If these are new vacancies, my lord, then Rule 8 mandate that you have to call the candidates in the ratio of 1:1.4 because these are not vacancies of that selection process. By creating 19th May 2022, my lord, the state has created new vacancies and there our right has been infringed because by whenever you are creating new vacancies, chance has to be given to everybody. That is violation of Article 14 and 16. There we are violated, my lord. We came before this honorable court saying that first you publish our Weimar sheet, publish the panel, and if you are to create these new vacancies, you have to follow the mandate of Rule 8. Now, my lord, for your lordship's consideration, may I read Rule 8? My lord, Rule 8. Information regarding vacancies. কোন ভলিউমে আছে এটা?
Very good. Rule 8. All right. Any other
My
argument?
lord, may I place Rule 8?
You have said, we have taken down.
My lord,
You have said that if it is a new vacancy, you have to follow the procedure in Rule 8.
otherwise it is a violation of Article 14 and 16.
Right, we understood. Any
Thereafter-
other argument?
Yes, my lord. My lord, Rule 15, my lord, says validity of the panel. Why I am saying placing this, my lord? Rule 16, validity of the panel. My lord, each panel and waiting list, my lord, that is very important. Each panel and waiting list shall remain valid for 1 year from the date of publication of the panel and waiting list or date of advertisement of the next recruitment process, whichever is earlier. My lord, no recruitment process has been initiated after this recruitment, this 2016. So, my lord, validity of the panel is 1 year from the date of publication of the panel. Next, notwithstanding, provided that name of candidates shall not be recommended against any post other than the post applied against any vacancy which has not been notified in terms of sub-rule 3B of Rule 8.
That is Rule
8.
No. What is the substantive rule?
So substantive
16.
rule is, my lord, West Bengal.
No. Rule 16 or
Rule 16. Validity of panel. My lord, now, my lord, Rule 19. Yes, my lord. Rule 19, my lord, says carry forward of the vacancies. If any vacancies remain, then I can take it.
All right. So your contention is that this was the actual contention of yours.
Yes.
That there has been a deprivation since these rules have not been followed and supernumerary post, if at all created, that ought to have been created in consonance with the Act.
In consonance with the Act, giving us also
an opportunity to participate.
And my lord, my fundamental point is, my lord, any recruitment has to govern by its rules. It cannot go beyond the rules. My lord, the rule says a panel.
That is an argument on merit.
My lord, no, my lord, the maintainability, for going into the issue of maintainability, my lord, on facts, it is required, my lord, how am I aggrieved and what injury it has been caused to me. My lord, if after everybody is saying we are unsuccessful, after the panel has expired, our status and their status is same. My lord, I am grateful to you all. So we stand on the same footing. So the question that we are unsuccessful, we cannot file the writ petition is not at all tenable, my lord, because where we stand now and where they stand, we stand on the same footing, my lord. And my lord, this when on the face of the constitutional court, a point has been raised that there is corruption and there is violation of rules, my lord. If your lordship goes to the impugned order, my lord, Supreme Court on n number of occasions from 1996, from 2025, Supreme Court has said not a single appointment can be given after expiry of pen. Waiting list cannot be treated as a reservoir. My lord, I am reading paragraph 27 of the impugnment, and your lordship did not have to find. I'm just reading, my lord, from paragraph 27. The petitioners are alleging that has been created in the name of supernumerary post. As such, all participants in the said relevant selection test have a right to be considered against those vacancies. The allegations need to be investigated on merit, and without such step being taken, the writ petition cannot be dismissed on the ground that the petitioners being unsuccessful in the relevant selection test have no locus standi to maintain the writ petition. My lord, another thing, let us take, my lord, for argument's sake, the honorable division bench, though I am saying that they are not. The applicant stated, the honorable division bench has stated, you heard the point of maintainability first, and the, my lord, single bench declined to hear it. My lord, they argued on merit. They have not challenging that the single bench will not hear the maintainability first, they will hear it together. They argued on merit. Now, my lord, they are stopped and cannot come before your lordship and say the maintainability issue was not taken up. My lord, it is not the fact. Please, my lord, it is. My lord, I think I did not interrupt when they were submitting.
Today you have adopted a regulation.
My lord, I was appearing for the state.
Ah.
But I'm sorry, my lord, I could not respond when your lordships were inquiring about me.
Yeah.
No,
But would you,
again adjournment will be taken.
no. I'm here to, my lord, argue the matter.
But at a very
But give me, my lord, on the locus point, give me 5 minutes on the next day. Or I can finish it today itself.
Locus, you both the issue, two issues, interim order in total entirety has been challenged before us.
Right.
So we cannot say that the challenge appeal in respect of one issue is accepted.
No,
And
certainly not. Certainly not.
So we have to give answer, judicial answer to the query raised by the appellant in respect of both the issues.
Right.
Hmm.
And in fact, my lord, your lordship would also find, just, my lord, not to, my lord, conclude things today, that, my lord, they were,
just one second.
I'm sorry, my lord.
We preliminary heard regarding mental ability issue and what is the issue, other issue.
Yes, my lord.
So
Okay.
this has to
Appellant
be
will
gone
be
in.
invited to make their deliberation on the both the issues.
The Supreme Court order,
Right.
Bhattacharya, where, my lord, the Supreme Court did not keep the question of creation of the supernumerary post open. This is one fact which must be brought to your lordship's notice. Lord, in the additional,
So for that we have to go into the merits, Mr.
Yes. Your lordship would hear us, my lord, on this.
But
Your
if
lordship
you
would definitely hear us on this.
not argue any other point,
No,
but you decide the mental,
No.
then it becomes difficult for
my lord is of the view that my lord will hear out the entire.
prima facie. It appears that we must go into it. If you want us that then you pass an order to that effect, we will test it in Supreme Court. That is another aspect of the matter.
In this way.
In this way, Mr. Kaur, how can we proceed? So we would request Mr. Sengupta, we have heard you on the point of merit, argue on merits and finish it up. We will finish it up. Yes, Mr. Sengupta, you have any problem to that?
But I think Mr. Sengupta is not online.
Yes, yes.
Yes.
Oh,
Very much.
Oh, you are online, you are offline. Don't
And Mr. Advocate General was of the understanding.
No,
Since there is a
I'm sorry,
rising
my
of
lord.
court at 3:30, Mr. Sengupta has left as usual.
take it up with him in other fora. So, Mr. Sengupta, we are desirous of hearing you on merits of the matter. You have argued on the mentality point. You say when you are arguing on merit, we will decide it.
Okay.
Chalo.
My lord, only one humble request before your lordships, my lord.
That is
Next day.
only thing, my lord,
In this way,
the said issue.
allow your senior to say,
We are, sir, inviting, we have told Mr. God, prima facie, we think that it has to be gone. Now, if after this, if we invite your senior, he has to return his argument on that, then now we can decide. Or you can say that no. First you answer whether it is
it cannot be.
My lord,
In respect of
my lord,
one matter, 5 judgment cannot be.
lordship has
On
rightly
the issue of first issue,
my
one
lord,
judgment,
pointed out
second
that
issue, another
their
judgment.
issue has to be gone into, my lord. I believe Mr. Sengupta, my learned senior, Mr. Court, the state, my lord, our chance after, my lord, 4th May, they will also take some time, my lord, since I am being led by Mr. Murray, after 4th May. In the meantime, your lordship can fix any date, they can complete. This is only one.
Sir, we have other matters also.
My lord, my lord, I understand, my lord, your lordship kindly consider, my lord, our
It will go in May.
It will go in May also.
We have
appear on behalf of the respondent number
But
3.
Alright.
ultimately, your lordships are going to merit.
Yes, Mr.
Yes,
Singh.
both the
Yeah,
issue.
both the,
Both
you
the
have
issue.
argued on maintainability. We are fixing a date. You argue on the main matter. We will finish up the case.
And Mr. Dasgupta will say, if it goes to Harab, since Mr. Sengupta argued on merits also, they are stopped from questioning that.
I've said, if we find that the repetition is not maintainable, there is no question of going into the next.
Yes.
Find is maintainable, then the question of determination of next issue will come.
We
My
have,
lord, we will address your lordship, my lord, on the merits without prejudice to our point of locus.
Yes.
We'll
yes.
make those submissions.
we have extensively heard Mr. Sengupta and Mr. Sengupta, learned advocate, the senior advocate appearing for the appellants in MAT
MAT
2171 of 2025. As also Mr. Duport, senior advocate appearing for the appellants in FMA 74 of 2026. Mr. Mr. Dasgupta, learned advocate. However, Mr. Sengupta extensively heard. However, due to paucity of time, the learned advocates appearing for the state and the respondents. We have extensively have not been able to conclude their arguments. In view thereof, list the matter for further consideration. The daily supplementary list of this I didn't get. 11th date. On 11th May as fixed at 2 p.m.
Here, Kunda.
For addition of party, my lord. Well, 4 matters were heard together and analogously, and judgment was passed in all the 4 matters, my lord.
All that.
কোথায় আছে 5:30?
Deeply open.
তো ওই যে কি নাম প্রতীকের জুনিয়র